premature termination and depriving the petitioner who has been prejudiced of substantial relief. The argument of the learned advocate general that the 3 years period, well, the same argument is being advanced here in para 48. The argument of the learned advocate general that the 3-year period of leaves from 8th November 85 to 7th November 1988 cannot be extended under any circumstances is not tenable, as the lease deed itself contains a clause of force majeure where this is contemplated. His other submission that this should not be done in the facts and circumstances of the case because large amount of money have been spent by Haryana Minerals because it was given to a public sector undertaking, state PSU, is also not acceptable, as large amount of money were also spent by the petitioner to get the mining operation started. The fact that the petitioner could perhaps file a suit for that, they also ruled out Miller's SR Act, Section 14(1)(c). That was the argument of Mr. Sival that he should go for the performance of a day. Also in para 45 they held, appearing for the next para Miller. The fact that the petitioner could perhaps file a suit for damages as the premature termination has been quashed will not be an equally efficacious and adequate remedy. Because 226 comes to play Miller or equity is given a go. And the estoppel lordship knows there can't be any estoppel against the statute. Statute Miller protects me for a period of 50 years. If there is an unlawful interruption, then I may not cite any authority, though I have got some decisions on that score, I will pass it on. I don't think it's a well settled proposition of law by now, that there can't be an estoppel against law. So, Mr. say that the same thing contains some hospitality here. Mr. Siebel, appearing for respondent number 3, has also asked that for breach of a contract, the petitioner is not entitled to exclusion of the period, as specific performance is not granted of a contract which is terminable. Further, the petitioner can be adequately compensated by damages. He relied on the decision of Santosh Kumar versus Central Warehousing Corporation, 86 Supreme Court so to endorse his submission. What is prohibited by law cannot be enforced by way of Article 226. That has been very beautifully answered in the next paragraph. It is apparent that this is not a case of contract simplicity, and provisions of Section 14(1)(c) of the Specific Relief Act are not attractive. This is a case of a breach of a statutory duty, because the right flows from statute to itself to give an opportunity of so and so, so and so. Let the summary of the judgment period, they have extended that period. Para 49, we allow the petition quash the impugned order. We also issue a writ of mandamus to the respondents to restore possession to the petitioner immediately. We also direct that the period of unlawful interruption, for which Lord I am praying before Lordship, shall be excluded in computing the 3 years term of the ledge. So this unlawful interruption, Lord, I've been trying to get this, fortunately it come in my head. So that one judgment is the other side will cite. That is, let me be fair with you also, RP South, a divisional bench, but the facts of that case are entirely different. There was a ban by the government, by the DFO. He did not have the clearance. He did not, lots of stay orders were there because of that common cause case, Saha Commission and all unlawful mining. My case is not a case of unlawful mining. I fulfill the statutory requirements. The nodal officer recommends, the director of mines recommends to the government. They sit over it. I go before the divisional authority. They also direct for resumption. Never confuse between resumption and renewal. You permit them because of the satisfaction of the statutory norms and requirements. They sit over it. Subsequently, by virtue of amendment of law 883 is introduced, but they say that Sao is also similar is a case with a 1953 lesson. He had already operated for 67 years beyond the statutory period of 50 years. This judgment is the other side, because I also came across this judgment last night. So, your Lordship can kindly turn to the facts of that case are entirely different. So, there they say, and the news period was also over by the time he go to the court. And it was given to Orissa Mineral Corporation, I think. That was given to a PSU. Orissa OLECL with effect from 1st April. Because this section 8A6 below, which was introduced in 2015 Amendment Act, is a non-obstantive clause. Notwithstanding the override, the period cannot be extended beyond 31st March 2020. It is a case of that. He was falling under that category. A lessee of 1953 with first renewal, second renewal, third renewal. He was in the case of third renewal, and the last ultimate deadline was 31st March 2020, and by no means, because that this clause had overriding effect, 8A subsection 6. So my case doesn't fall within the factual backdrop of SAR. So another case, a small Arjun Lodha, a party had directly approached under 32 to the Supreme Court. His lease was long expired. He went to Supreme Court, claimed some last period. That was also dismissed. These two judgments, the other side, they tried to take a request to frustrate my claim. But this is the position of law. So now I will leave it to your lordship's judgment.
Make these elections. But first, kindly see the judgment of your lordship's court in R.P. Saul's case, because he stopped with that. Let me begin with it.
The judgment, R.P. Saul. My lord have R.P. Saul?
Yes.
Well, may I read his judgment because this squarely covers our case. Heard Mr. So-and-so and Mr. So-and-so, the petitioner who is the lessee in respect of Guwali iron ore mines over an area of so-and-so hectares in village Guwali, so-and-so, reserve forest under Badwil Tahsil, Champua division of Keonjhar district has filed the present writ petition seeking restoration. Kindly underline these words. Kindly seeking restoration of the lost period from 27/6/2013 to 16/5/2014, that is 10 months and 20 days, and from 23/5/2015 to 10/4/2018, that is 34 months and 19 days. Thus, a total period of 45 months and 9 days for which the lessee could not operate its mines due to interruptions. Lakshmi kindly note interruptions, disruptions caused which was beyond the control of the lessee, more particularly when such disruptions were caused mainly by the act of omission on the part of the state government authorities. He further submitted various legal proceedings are pending before this court and the Honorable Supreme Court in respect of the mines in question. You actually only note this mines was coming to an end on 31st of March 2020 under a statutory provision. I'll show that to your lordships. The substratum of the challenge of the petitioner in this writ petition is the decision dated 22/10/2019 of the state government communicated to the petitioner under Annexure 30 to allocate the mining question in favor of Orissa Mineral Exploration Corporation Limited for ready reference. Relevant portion of Annexure 30 is quoted below. You actually skip that. That's not very relevant. Kindly turn to the next paragraph. Paragraph 3. When a counsel for the petitioner may be contended that the tenor of the agreement which was entered into between him and the government, and more particularly in view of the last extension agreement, like here which ends on 24, and whereas this supplementary lease deed is a part and parcel of the sale deed, and the terms and conditions are in furtherance to the terms and conditions, in addition to the terms and conditions agreed to in the said lease deed, he is entitled to the relief sought for. Emphasis is laid on Form K, Part 9 of the Mineral Concession Rules 1960, Clause 4 of which is post reliance. For better appreciation of the facts, Clause 4 of the Form K is quoted hereunder. That is what force does apply, which your lordships have seen. Now kindly turn over the page numbers. Paragraph 4. It is contended that the petitioner was not allowed to carry on mining operations from 26/2013 to 16/5/2014, that is 10 months and 20 days, from 23/5/2015 to 10/4/28, that is 34 months and 90 days, thus a total period of 45 months and 9 days. In this regard, we have made a representation which has not yet been paid heed of, And in the meantime, the government has decided to lease out the mines in question to ONCL, which is a state-run corporation. As such, the action of the government is contrary to 1782 reservation. Granting to a private public sector under 782 is saying is bad. Since there is no approval as yet from the central government, issuance of Annexure 30 runs contrary to the provisions of the MMDR Act. The further contention of Sri Gupta when its senior counsel appears, it is pursuant to Annexure 15 that communication dated so and so, Special Secretary Government of Orissa Department of Steel, extension of period of lease from 2013 to 31st March 2020, the petitioner has deposited 82 lakhs, 82 whatever, towards stamp duty and the little so and so towards registration fees. So he says stamp duty and also registration fees. Regarding the lease, as per the original agreement on the supplemental agreement of referred to above, it is concluded that the amount of stamp duty and registration fee should correspondingly be reduced for the period. So the amount of the stamp duty which I paid. In support of his contention, so Lordship has skipped 7. Kindly come to paragraph 8 at page 7. You have to straight away come to the paragraph 9 at page 8. Taking into consideration the above, my lordships have it, paragraph 9 page 8. Taking into consideration the above, it has been argued by Mr. Gupta that non-operation of the mines in question was accepted by the government. It is further contended that pursuant to coming into force of the MMDR Act 2015, the extension of lease period was through a supplementary lease deed, wherein the state government accepted the payment of stamp duty and registration fee for the entire period of extension. He further contended that rules, more particularly clause 4 in Form K of the mineral concession rules, should be read harmoniously with the provisions of Section 8A of the MMDR Act. Similar argument that there is a force majeure clause and we are entitled to extension. In the alternate, Mr. Gupta's contends that as per clause 4 of Form K of the mineral concession rules, the petitioner is to get 6 months breathing period after expiration of the lease. You are under law. Once your lease is expiring, you get 6 months time to remove the minerals, machines, etc. So that is what he is saying. In view of such provision, the decision of the lease mines in favor of MECL with effect from 1st April 22 as per Annexure 30 without lawful authority. But we are not there. Now kindly turn to page 10, para 11. What is the contention of the state? Mr. So-and-so, appearing for the state of Orissa, has taken us to clause 6 of section 8A of the MMDR Act 2015, which is quoted here under. Your Lordship saw 8A3 yesterday. This was 8A6 case. Periods for which grant of mining is for minerals other than coal, lignite, and autonomic minerals. Notwithstanding anything contained in subsection 2, 3, and 4, the period of lease granted before commencement of the MMDR Act 2015, where mineral used for other than captive purposes shall be extended and be deemed to have been extended up to a period ending 31st of March 2020, with effect from the date of expiry of the period of renewal last made, or till completion of the renewal period, if any, for a period of 50 years from the date of grant of such lease, whichever is later, subject to condition that all the terms and conditions of the lease have been expired. So 2020 was his last day under 8A5, under 8A6. In view of the matter, in that view of the matter, it is contended that extension beyond 31st of March 2020 cannot be granted unless there is a renewal prior to the Amendment Act of 2015 coming into effect, that is 12th of January 2015. Here the renewal was made after 12th of January. So is the case in the present case which we are discussing. There is no extension. Prior to 12th January 2015, Form K, will have the argument on force majeure. This was our submission. Form K or Rule 12(1) FF, whichever way, if it is contrary to the substantive provision of the Act, cannot be allowed to operate, and it should always be read in harmony with the substantive provision. We have heard that counsel for the parties, peruse the records, in view of the MMDR Act Amendment 2015, and more particularly, there is no extension of record after 2013, and the petitioner having accepted the supplementary lease deed of 2015 up to 31st of March 2020. Because in our case, he has accepted it until 2024, what the Lordship saw yesterday. In our considered opinion, it would not be appropriate to extend the lease period or grant the petitioner 45 months, 9 days, contrary to section 86 of the MMDR. The lease period which was accepted by both the sides up to 31st March 2020 is in consonance with the MMDR Amendment Act 2015. In that view of the matter, the petitioner cannot be allowed to operate the mines beyond 31st March 2020, which will contravene the provisions of section 86 of the MMDR Act. In that view of the matter, the contention of the petitioner that the affidavit which was filed before the Honorable Supreme Court and referred to herein above, with reference to the present context, cannot yield any benefit to the petitioner in view of the explanation of so and so, to the effect that the Honorable Supreme Court, in a proceeding, pending for it, directed the state government to give a list of each mineholders, whether they have complied with the statutory requirement or not, having accepted the supplementary. But this is very important. Having accepted the supplementary lease deed, in 2015, the petitioner cannot possibly raise any objection for the execution of the lease. Because this squarely fits in to our case. He signs a supplementary agreement till 2024, signs it without demur, and now he is saying that my lease period has to be extended. And the period for which he is asking for is the period prior to signing the lease deed. However, it will not be appropriate to allot the mining lease. This is another question. However, it will not be appropriate to allot the mining lease to the government-owned corporation as per so and so, but hearing at such beginning stage, so we are not concerned with the allotting to third party. So what the lordship hold in this case is that there is a statutory time limit under the Act. That time limit has been exercised. You have executed an agreement without demur. Now you cannot say that I will get time beyond the agreement which I have signed. This is one judgment completely on the point. But there is another judgment you have to kindly see. It's a Karnataka judgment only to show your lordships why this MMDR Act was amended. Yes. Why this MMDR Act was amended and why this extra 20, 20, 50 years, all that was made for old leases. Kindly come to my lord, if you lordship come to page 20 of this report, paragraph 51. But in this judgment, the judgment of justice, the first judgment which my learned friend cited, has also been taken note of.
Oh, in Sahu also both the decisions have been taken into account.
In RP Sahu?
In RP Sahu also,
yes.
Though the two decisions on which he has placed reliance, taken note of.
Yes.
Case of,
I am grateful. So if your lordship now sees page 51 at page 20.
Yes, please. Please.
My lord may kindly see page 51.
Page or paragraph?
Yeah.
Paragraph 51.
Yes. Paragraph 51, my lord's.
Yes.
Just look at little below. Let me read, my lord, just a few lines towards the end. All the decisions relied upon by the petitioners for granting extension of lease period, my lordship have that line, was lease period have been rendered prior to 12th of January 2015. My lordship have that line, my lords.
All the decisions.
Yes, all the decisions relied upon, I'm sorry, there was one area missing. Relied upon by the petitioners for granting extension of lease period have been rendered prior to 12th of January 2015, when a major change was brought about in relation to the mining laws. The Amendment Act brought about changes. It will be necessary to refer to the statement and objects and reasons of the Amending Act. Paragraphs 4 to 6 of the objection reasons are relevant, which reads thus. The present legal framework of the India Act 57 does not permit the auction of mineral concessions. Auctioning of mineral concessions would improve transparency in the allocation. Government would also get an increased share of revenue of the value of the minerals. So this was one of the objectives of this new amendment, which was brought about in 2015.
Yes.
Some provisions of the law relating to renewals of mining leases, concessions have also been found to be wanting in enabling decisions. Consequently, there has been a slowdown in the grant of new concessions and the renewal of existing ones. As a result, the mining sector started registering decline in production, affecting the manufacturing sector, which largely depends on the raw material provided by the mining sector. The government has therefore felt necessary to address the immediate requirements of the mining sector and also to remedy the basic structural defects that underlie the current impasse. In view of the urgent need to address these problems, the Amendment Act, Ordinance 2015 was promulgated on 12th of January 2015, is to replace this ordinance. Here actually, kindly similar, what are the eliminating discretion? The bill is designed to put in place a mechanism for eliminating discretion. Roman 2 is now there, improving transparency in the allocation of mineral resources, simplifying procedures, eliminating delay in administration so as to enable expedition and optimum development of mineral resources. May I read the next paragraph? The salient features of India Act Bill 2015 are as follows. The removal of discretion, auction to be the sole method of allotment. Amendment seeks to bring out utmost transparency by introducing auction mechanism for the grant of mineral concessions. The tenure of mining leases has been increased from existing 30 years to 50 years. There is no provision for renewal of lease.
Yes.
You'll also now kindly turn over minutes and kindly come to page 22, paragraph 52.
Yes.
Thus, one of the basic objects of the Amendment Act was to make auction as the only mode of grant. Here also, I'm sorry, not missing of mining concessions. The existing provisions of the said Act do not permit auctioning of mineral concessions. Another object was to eliminate discretion and improve transparency in allocation of mineral resources. One of the salient features of the Amending Act was removal of discretion and introduction of auction to be the sole method of allotment of mineral concessions. By amendment, the tenure of mining leases was extended from 30 years to 50 years. Para 53. In case of Bhushan Power and Steel Authority versus so-and-so, the Apex Court referred to the statement of objects and reasons and observed that auction of mineral concessions, transparency in allocation will improve. In para 21, it is noted that the Amendment Act brought in the statute book auction as the sole method of allotment. Then para 54, Melody, what should my kindly skip, Melody? Para 55, let me read. As observed by the Apex Court in the common cause case, to avoid any prejudice to the existing lien holders. Lordships have that paragraph. Yes. The existing lien holders, like the petitioners, that the provisions of 80 of the said Act were incorporated, providing for firstly, extending the period of mining leases granted before 12th of January 2015 for a period of 50 years. So, Mr. Acharya's client was given an additional 10 years. And secondly, for providing a booming fiction Under subsections 5 and 6 of section 8A of the Act of 1957, which granted relief to lease holders in whose case the period of 50 years from the date of grant of the original lease had expired by 12 January. So if you expired, still they gave them 10 years. The intention of the legislature, as reflected in subsection 4 of section 8A, will be very important. The intention of the legislature is reflected from subsection 4 of section 8A of the Act of 1957, which provides that on expiry of the lease period, the lease shall be put up for auction as per the procedure specified in the Act of 1957. Therefore, subsection 4 of section 8A of the said Act of 57 means that whatever extension of mining is granted under any provisions of 8A on the expiry of the extended lease period, the lease has to be put up for auction. Because my submission is this is the legislative intent. This provision is consistent with the objects and reasons and the legislative intent of coming out with the Amendment Act to introduce auction as the only method of disposal of mineral concessions. Thus, extension beyond the period provided in subsection 6 of section 8A cannot be granted. Here, the Lordship have read 8A3 instead of 6. These are two cases where the petitioners were denied the benefit of lease extension for no valid reason. The question is whether the petitioners are entitled to relief of extension of lease beyond 31st of March 2020. So they are assuming that they were denied. Let us see whether they are entitled to extension or not. Firstly, in these cases, the precise loss of money in terms of money which is caused to the petitioners due to delay in grant of benefit of lease extension can always be quantified. The loss can be only a loss in terms of money. The petitioners can always approach the civil court. Secondly, in view of the legislative intent which is reflected in the amendments, what secondly is important. With effect from so and so, in light of subsection 4 of section 8A of the Act of 57, it will be inequitable to grant the relief of extension of a lease period. In any case, in both the cases, the petitioners were entitled to deemed extension till 31st of March 2020 by operation of section 8A of the Act of 57 and in particular subsection 6 thereof. Immediately after the expiry of the extended period of lease, the auction regime will come into the picture and the leases will have to put up for auction in terms of the provisions of the Act of 1957, in particular subsection 4 of section 8A, if the court grants a relief of extension of lease that will completely defeat the object of the amendment to the said Act of 1957 with effect from 4th of January 2015, and the object of introducing auction as the only mode of granting mineral concessions. The petitioner will not be prejudiced, and the loss of money which can be caused to them can always be compensated in terms of money. In fact, one of the two petitions reliance is placed on various decisions on the concept of restitution. The restitution can take place in form of damages, but it jurisdiction I am not. So my submission to Lordship is what they said is that the legislative intent post 2015 was everything should be auctioned. For leases which were continuing, certain relief was granted. Under 8A5 and 8A6, it was said.
Mr. Advocate General,
Yes, ma'am.
while relying on this decision,
Yes, ma'am.
are you relying on the conclusion part of that judgment also?
Well, I am not relying on that, but your Lordships have read it.
All right.
Well, I leave it to your Lordships. I leave it to your Lordships.
You will see.
Well, on a lighter vein, if I can tell your Lordships something. Justice Sujit Burman Rai was our Chief Justice. And one case was going on. And one of the senior counsels, late Mr. Arun Jaitley, handed over a paper to. The other side handed over a paper. And Mr. Jaitley, after 10 minutes, stood up and said that that is not by way of an affidavit. He returned the paper. And after some time, he told Mr. Jaitley, what do I do? I have read it. So it's already registered in my mind. So my agreeing or not, it does not make a difference. I am here to assist your Lordships. Now let us come to the facts of this case. And see, my lord, what is the law under which we are now governed. You will actually see section 8 capital A. That will be page 14 of your Lordship's book. Eight capital A. When your Lordships are dealing with a case which is post the amendment to the MMDR Act.
Just,
I'm so sorry.
it is at page 16.
I'm sorry. It must be the we have different books. 8 capital A. Miller.
8 capital A. 8 capital A. My book it is.
8 capital A. I was showing it to your Lordship yesterday.
2024.
Miller, can I hand over the book?
Yes. Yes, we are
Your
there.
Lordships have it? Yes.
We are there.
Yes. But if your Lordship sees this, there is a, this 8A, we are now talking about a regime which is post 12th of January 2015. Because 8A was inserted by Act 10 of 2015. That will be at the book at the foot of the page units. My Lord the Chief Justice have it?
Yeah, yes.
Yes. Now what it says, 8A, 1, the provisions of this section shall apply to minerals other than specified in A, Part A and Part B of this first schedule. Your Lordship need not worry about it. Kindly see 2. On and from the date of commencement of the Mines and Minerals Development Regulation Amendment Act 2015, all mining leases shall be granted up to 50 years. So 50 years is the outer limit. Now 3 is our case. All mining leases granted before the commencement of the MMDR Act 2015, but in this case, the lease was granted in the year 1974. This lease was granted on 21 of February 2074. So it was granted prior to 12th of January 2015.
1970.
21st February 1974. 21st February 1974. So all mining leases granted before the commencement of the MMDR Act 2015 shall be deemed to have been granted for 50 years. So therefore, 74 will go up to 50 years, which is 2024. Now what happens after 2024? Now what happens is, subsection 4 kicks in immediately after the expiry of that period. Namely, on the expiry of the lease period, that is subsection 4, the lease shall be put up for auction as per the procedure specified in this act. The submission to a Lordship is the contention being advanced by the petitioner is arrest subsection 4. By your mandamus, do not allow 4 to operate.
Yes.
So my submission is that once you have without demur taken the benefit of subsection 3, the logical consequence is 8A4. Once without demur, you took the benefit under 8A3 by executing a supplementary lease deed for 10 years. You now cannot say that arrest 8A4. Now let me read 8A6 because that was the judgment, Appeals House judgment of the 8A6 case. But 8A5 and 8A...
According to you,
Yes, ma'am.
the petitioner was conscious of the provision
I'm grateful.
under subsection 3 of section
I'm grateful.
8A
I'm grateful.
that the lease period could be extended up to that
I'm
date
grateful.
only, and therefore it
I'm
was
grateful.
extended, and that was accepted by him.
I'm grateful. That was why I'm sorry. I'm sorry, I interrupted you.
Yes, yes.
So that is why I started with the supplementary lease deed yesterday, and I'll show that document to you once again. Now, so therefore, 8A3 addressed cases where 50 years had not been completed. Somebody was in 30 years, somebody was in 40 years, somebody may have been 30 years. So he was granted that extra period so that they come in sync with the legislative intent that everybody should have it for 50 years. But I clear. The Act said 50 for new grants, but old grants who had not arrived at 50, they were protected. And 8A, 5 and 6 are two different provisions. They had crossed the period of 50. But they were subsisting. And on the day the new law came, they had a right for renewal. So some protection had to be given. So 8A, 5 said that if you are holding a captive lease, namely I hold a lease for my own industry, you will be granted till 2030. And if you are a non-captive lease, you will be granted till March 2020. So March 2020 for people who had gone beyond 50 years. And non-captive, if you are a captive, then 2030, and an additional 10 years. Because you have put up an industry, where will you go for work? That was the legislative intent. That is 5 is 30 years, 5 is until 2030 for captive, and 6 is 2020 for non-captive. And RP Sahu was a case of non-captive, and therefore RP Sahu was granted an extension till 31st of March 2020. Now, what RP Sahu came to your lordship for was that, look, for reasons beyond my control, for reasons attributable to the state, I could not work for X amount of period, so therefore kindly extend. Am I clear, Lords? That was the prayer. Your Lordship said that having executed a supplementary lease deed till 2020 March without demur, you cannot now raise a new complaint because ultimately after 2020 that lease will be put to auction. And they considered the Supreme Court judgment here, which has been cited by my learned friend. Why I cited Karnataka? That gave your lordship the legislative intent, the legislative history, which is, I thought instead of reading the book, I might as well read it from that judgment. So, in my humble submission, my lords, this relief which is being sought for is contrary to statute, namely 8A4, and therefore,
Yes.
not available to be granted as a prayer for equitable relief.
Yes.
And your lordships have already read in RP Sahu that force measure has to be read in a way it does not become inconsistent with the statutory provisions. The force measure is the rule, it's in the form. So the lordships have to reconcile where force measure will apply, where it will not apply. I will give your lordship an example. If you do not work the mines for a period of 2 years, under section 4A4 it will lapse. I can come and tell your lordships that the screw period is hindered on account of the state government. So therefore, I should not be held responsible. My lease should not be lapsed. There will be several situations like this. But force measure will not be intended to arrest 8A4.
Yes.
Now, the argument of my learned friend proceeds that the Delhi High Court judgment was a judgment prior to the amendment made in 21-2015. So 12-1-2015 was the new act. Delhi High Court judgment was prior in point of time when there was no concept of auction and there was no provision like 8A capital 4.
Yes.
Second, admittedly, it was a case of premature termination.
Yes.
So therefore, this judgment does not help our case at all.
Yes.
And this also proceeds on the assumption that there were hindrances created by the state, which I will satisfy your lordships on facts is not the case here. we are not going into the facts because on law also I succeed. But why you were not allowed to mine is an issue of fact. If you want, I will address the lordships on that. I have a small list of dates. This is without prejudice to what I had submitted before the lordships on law minutes. Would your lordship read 12.1 FF?
Please give him also a copy.
Yes. I've already given. If your lordship sees 12.1 FF,
394.
that fourth paragraph clause works, should be at page, it's page 394 of my book, Millets.
Yes.
Well, my first submission is FF and that part 4 of the lease deed has to yield to the statute. Well, that was what your lordships accepted in RP South's case. But even otherwise, FF is only a protection to the lessee for his default. May I read this? Failure on the part of the lessee to fulfill any of the terms and conditions of the Act and rules made thereunder or under the mining lease shall not give the central government or the state government any claim against the lessee or be deemed to a breach of the lessee insofar as failure is considered by the relevant government to arise out of force majeure. So therefore, it is actually a shield and not a sword.
Yes.
It is for his protection. If for some reason he could not comply, here he is using it as a sword. He is saying, look, give me extra time because force majeure. Force majeure is not that. It is on account of his failure. Kindly see the second part. In the event of any delay by the lessee to fulfill any terms and conditions of the Act and the rules made thereunder or under the mining lease on account of a force majeure event, the period of such delay shall be added. This again is on account of a default by the lessee. In both the cases, my lords.
So this is what he is submitting.
Yes, my lords.
That of course it was on account of the lessee,
Yes.
but because of the lapses on the part of the state government.
I gave you lordships an example. There are certain things under the Act and the rules which the lessee is required to comply. And if the lessee does not comply for reasons beyond his control, then he will get the benefit of that period. Namely, not extension of the lease. If the lease requires him to do a particular thing within a particular time, or the rules of the Act requires him to do a particular thing in a particular time, and he fails to do it for reasons beyond his control, then this comes into head. So this is a shield. You'll actually see section 4A4 for a minute of this Act.
Yes.
I'll give you lordships an illustration straight away. So he will not be penalized for reasons which are beyond his control. That is the purport of 12.1 FF. Kindly see section 4 minutes. 4A4 of the Act minutes. Where is the lapsing provision? If you will actually kindly see minutes, there is a section called section 4A4.
Yes.
My Lord the Chief Justice has it?
Yes.
Yes. Where a holder of a mining lease, my Lord Justice Das has it, 4A4.
Yes.
I'm just giving an illustration. Where the holder of a mining lease fails to undertake production and dispatch for a period of 2 years after the date of execution of the lease, or having commenced production and dispatch, has discontinued the same for a period of 2 years, the lease shall lapse on the expiry of the period of 2 years from the date of execution of the lease, or as the case may be, discontinuing of so and so. One lessee can come to your lordships and say that this 2 years, for which I could not start the work, or for which I discontinued the work, if it was for reasons beyond my control, I am protected under 12.1 FF. Because here under the lease deed and under the Rules Act, he was supposed to do something within a particular time. But he could not do it because for no fault of his. He can invoke 12(1) FF and address your lordships that look, this 2 years period has to be now extended. So that is the purport of 12(1) FF, notwithstanding my argument, my lord, that 12(1) FF has to always yield to the substantive provision of the Act, namely 8A3 and 8A4.
Yes, we'll see.
Now I will give you lordships a small list of dates. I think I have given it to the teacher.
Yes.
My lord, one more argument. Presently, we are dealing with a mineral called dolomite, which admittedly is a minor mineral. And under the Orissa minor mineral rules, there is no perimetry provision like 12(1) FF, subject to correction by my learned friend, my lords. There is no 12(1) FF under the Orissa minor mineral concession rules, subject to correction by my learned friend.
Just a minute.
Because we are dealing with dolomite. Dolomite, right? Dolomite. And dolomite has become a minor mineral with effect from 10th of February 2015, and that is as per the Gazette notification, my lord. As per the Gazette notification, which your lordships will have in an additional affidavit filed on 6th of February 2024.
Yes.
If your lordships want to see that document, my lords, it is there in the additional affidavit of the state government filed on 6th of February.
Just a minute.
I'm so sorry.
Which,
It is an additional affidavit filed by the state government on 6th of February 2024, filed on 7th of February. Sworn on 6th of February, filed on 7th of February.
Gazette notification dated?
There's a Gazette notification of 10th of February 2015,
Yes.
page 13, 1-3.
Yes.
And your lordships will see, my lord, this is dated 10th of February 2015. At the top, my lordships have it.
Just.
Page 1-3 in English,
Yes.
and the previous one is in Hindi. And if my lords are kindly pleased, lords, in exercise of powers conferred by subclause E of section 3 of the India Act, the central government hereby declares the following minerals to be minor minerals, in addition to the minerals already declared, and dolomite is Roman 11.
Yes.
My lord, the Chief Justice has that page here?
Yes.
Yes, so dolomite is a minor mineral with effect from 10th of February 2015 and subject to correction by my learned friend, my lords. There is no provision perimetry to 12(1) FF under the Odisha minor mineral rules. Now, my lord, that list of dates I have given to your lordships, I will satisfy your lordships that there has been no contravention or there has been no illegal disruption by the state government.
Or no lapse.
No lapse, no lapse. It is a reasonable lapse. On my account, for which he could have invoked 12(1) FFs. You will assume there was no 8A3 and there was no 8A4. There was no 8A3, there was no 8A4, there was no 2015 amendment. Would somebody have said that there is a lapse on my part for which you would seek restitution, either by way of extension or by way of damages, whatever? Now kindly see the few dates. But the lease was granted.
Yes.
On 21st of February 1974, lordships have it.
Yes.
For the 20 years, he applies. So 74 to 20 years would take him to 94. Am I clear, lords?
Yes.
Now, under the rules, he has to apply for renewal 1 year before. He applies for renewal on 16th of February 1993. On 7/11/2009, his mining operations were stopped for want of statutory clearances. To carry on mining operations, you require three clearances. One is the mining plan, one is the forest clearance, one is the environmental clearance, and the fourth one is a consent to operate by the State Pollution Control Board. You require four clearances.
Yes.
So 7/11, he was asked to stop mining operations for want of statutory clearances. Now you will also stop on provision now that if you don't work, it will lapse. So since he was not working, he files an application on 23rd of March 2011 to save the lapsing. There is a rule 28(2), you can apply for saving the lapsing.
So which is this annexure?
23 March 2011. But I'll tell you what chips in a minute.
Please give us the annexure.
Yes, I will tell you what chips.
Please. Please continue, Mr.
Yes. 6/11/2011, as there was no mining operation for the period of 2 years, from 7/11 to so and so, the mining means was lapsed on 4/4. You actually leave that. Kindly 16 January. This is what he is saying. From 12 to 15, I was prevented. That's the case. The DDO wrote a letter to the Director of Mines, Orissa, including a statutory clearances furnished by the petitioner. The application under 28(2), which he had filed for saving the lapsing, was forwarded to the government on 19th of March 2012. But on 4/5/2012, notice was issued to the petitioner under Rule 26(1) of the Mineral Concession Rules, MCR's Mineral Concession Rules 1960, not the old rules, directing the petitioner to appear on 16/5/2012 for personal hearing. Well, what is 26(1)? Before I dispose of his renewal application, which your Lordship saw he had filed at serial number 2 on 16th of February 1993, he was called for hearing. On 16/5/2012, he appears for personal hearing and he was requested to submit a mining use clearance certificate, which is called as MDCC. But there are two submissions on this. If you do not have a mining use clearance certificate, you will not be given a transit pass to operate the mines. Secondly, your renewal also cannot be processed. Pursuant to 24A of the Mineral Concession Rule 60, one lessee has to submit Form J for renewal of mining lease. Clause 2(6)A of Form J stipulates to include the mining use clearance certificate along with the renewal application. For 3/5/2012, petitioner applies for MDCC clearance from the Director of Mines, Orissa. So now he is applying for MDCC. So admittedly, he had not filed the MDCC along with the renewal application. Now 25/6/2012, the application for MDCC of the petitioner was rejected by the Director of Mines as there was an outstanding due of 2 crores 10 lakhs. This is really important. Why it was levied? On account of excess production beyond the statutory limit under 21(5). Now, on 4th of August 2012, being agreed with the rejection order dated 25/6/2012, petitioner filed a revision application before the central government under Section 30. So now see, Lords, from 4/8/2012, he goes in revision, and the revision is disposed of on 7th of January 2014. I'll come to that shortly. So on 4th of August 2012, he files a revision, being agreed with the order of 25/6/2012. Notice was issued to the petitioner fixing another date of personal hearing on 28/12. Petitioner was heard both in connection with the renewal application and his application for exemption of mining lease. Petitioner filed second renewal application. Now kindly note what is 13th of February, he is filing a second renewal application because that 20 years has already lapsed. The first renewal application was made in 1993. 20 years takes him to 13th of February 2013. He is filing a second renewal application. On 31/7/2013, The original application was heard by the reviewing authority challenging the reduction of issuance of mining dues clearance certificate. My lordships have it, right?
Yes.
On 7/9/2013, notice was issued to the petitioner in respect of the first renewal application. On 7th of January 2014, the reviewing authority disposed of the renewal application. It set aside the demand. Your lordship just, well, I do a small correction. The demand has not been set aside. I will show it to your lordships. It further directed the state government to allow resumption of mining operation till the expiry of the current lease period up to 20/2/2014. So, my lord, the revision application was filed at serial number 12 on 4th of August 2012 and it was disposed of on 7th of January 2014, almost close to about 18 to 20 months. It was pending before the revenue authority. And no interim order was granted by the revenue authority.
That was beyond his control. This is what is.
No, that is, it was pending in court. It was pending adjudication before some courts.
Therefore.
Yes.
He's saying.
No, well, I'll address it. I'll address the lordships on that. Wait a minute. Now, what the revenue authority said, that I will not go into the correctness of that demand of 22 crore 10, and I will read the revenue order now. I will ask myself the question that whether you can carry on mining operation if there is a due against you. Milord, your lordship, the rule is, Milord, there is a rule called the Orissa Minerals. Orissa Minerals Prevention of Theft, Smuggling and Illegal Mining and Regulation of Possession of Storage, Trading, Transport Rules 2007.
Yes. PTSI, MRPS.
I am grateful to lordships.
Yes.
So what it says, Milord, for carrying out mining operations, for storing of minerals, and for transportation of minerals, you require certain licenses. Well, I will mine, then I will have to store, and then I will have to take it from one place to another. So I need certain transit permits, etc., for working it out. And let us see if somebody has a due payable to the government, is he entitled to those? But I am only trying to show your lordship to say that it was not on my account, even though the main argument is 83. Now kindly see Rule 3. My lords have Rule 3.
Yes.
Lordships have Rule 3. It's in that book. Should be page 207. In my book, it is page 207. Not the same book, lords.
I'll say.
My lord Justice Das has it.
No, I'll get.
Kindly see, my lord, it says restrictions. My lord, restrictions.
Yes, restriction.
And kindly see, my lord, the proviso, 5th proviso. Fifth proviso.
Yes.
Provided also, no license shall be granted to any person unless a person is of Indian national or a company as defined under the Companies Act. And we are to the next one. Not a defaulter in payment of mining dues payable under the Act. So if mining dues are payable under the Act,
Where did you read?
Lord, I read the 5th proviso.
Fifth proviso.
I am grateful, Lords. Provided also, no license shall be granted to any person unless a person is of Indian national or a company is defined and so and so. Can you look at the next one, Lord? Not a defaulter in payment of mining dues payable under the Act.
Yes.
Lord, I am arguing something beyond the pleadings, beyond the case, only to satisfy your lordship. That on facts also, even otherwise, it cannot be said that it is solely attributable to the state.
Yes.
Number one, the question is whether the review authority came to the conclusion that no dues were paid.
Revisional authority.
Yes, sir. Because your lordship knows he went in division where there was a direction that allowed him to work. And let me complete the list of dates. I'm so sorry, but I should have done it before. So the revisional order, your lordship saw at serial number 18. Which is at page 155 of the petition, of the writ petition. The revisional authority did not render any opinion on the validity of the demand raised. Well, as your lordships have, as I told your lordships, this revision petition application was filed challenging the demand, the rejection of the mining dues. And your lordships will get it right.
Whether the demand was challenged or rejection of mining.
The demand was challenged.
Demand was challenged.
Demand was challenged. So what I'm trying to tell your lordships is that when he applied for mining dues clearance certificate, he was told that look, you have to pay 2 crores 10 lakhs which is outstanding. And that your lordships will see at paragraph 6, page 156 of the revisional order.
Paragraph 16, I think.
Paragraph 6, page 156 of the revisional order.
Yes, this revision petition.
I'm grateful. Accordingly,
That is 16.
no, I was getting page 156, the second page. I'm sorry, minutes.
16 is the operating part.
No, I said para 6.
6 is there.
Yes, just to show why the revision was filed. Just to show your lordships why the revision was filed. My lord, the Chief Justice has it, perhaps?
Yes. Which paragraph? 6?
Paragraph 6 at page 156.
And 16 is the complete.
Yes.
Accordingly, the lessee revisionist applied for MDCC on 35/2012 to the Director of Mines, which was accepted online, but the MDCC was rejected by the Director of Mines on 25/6/2012 on account of outstanding of a sum of rupees so and so against the lessee towards the cost price of mineral produce, excess quantity stipulated in the consent order of State Pollution Control Board during the period so and so to so and so. So that was the challenge. And let us see here what the revenue authority ultimately held. Kindly turn to page 158,
Yes.
paragraph 16.
Yes.
The revisional petition is not about determining the correctness or otherwise of the demand of so and so raised by the state government on the basis of the report of the accountant in Odisha. It is for the state to give a complete account and particulars of the dues which the revisionist is liable to pay, and the revisionist may submit appropriate representation in case he wants to dispute the demand raised by the state government. So he doesn't get into this dispute, although he says they have come here for this. The state government may, however, take into consideration the provisions of the newly inserted 2(1) to Rule 2, Roman 2 of the MCR, as amended by MCR 2012, which defines illegal mining, paragraph 17. The revisionist at the time of hearing and also the written submissions that he has subsequently filed has pressed to declare the amount as not recoverable under law But since the issue of recoverability or otherwise of the amount is not a fact in issue in revision, it is not necessary to decide the matter at this stage. So the revision authority also does not decide whether that amount is payable or not. Kindly see the next one. There could be no doubt that the current lease period started on so and so will continue till so and so. The mining operation was suspended for want of environmental clearance and number. And since clearance has been obtained and filed by the revision, there should be no bar in resuming proceedings during the subsistence of the lease period. Kindly note that. He is saying during the subsistence of the lease period. Even otherwise, the state government is directed to allow resumption of the mining operations till the expiry of the current lease, that is up to 20th February 2014. And see the date of the order here. This order is dated 7/1/2014. So what he's really saying is, allow him to work for 23 days. 7/1, 23 days this side, 19 days that side. This order is dated 7th of January. 7th January? 7th January 2014. And he is saying, please allow him to work. Please allow him to work for 20 days, 20, 30.
No, more than 20 days, more than a month.
Yes, but let us say 23 days this side and 19 days that side. And it does not decide the issue as to whether dues are payable or not. So my humble submission is, these were pending in different forums.
No, but did he pay the amount? Just for the.
Well, really, honestly speaking, I don't know. But the fact remains that there was a supplementary agreement and he has been allowed to work. He has been allowed to work. So the submission is not that he went to the tribunal. The tribunal ultimately gave him the direction to work. It could have passed an interim order. It did not do. So it was locked up in litigation. That's the submission. And my submission is, these are all by way of clarification. My main submission to your Lordship is that post-2015 regime, 83 gave him a 10-year window to work, which he has worked, and which is continuing to work. And that 10-year window was the statutory impediment post-2015 amendment. Your Lordships migrated from the 60 old Act of 1957 to a completely new regime in January 2015, and under that 15, his rights are circumscribed by 21(3) and 21(4). He has enjoyed the benefit of 21(3). Your Lordship may kindly see me not just for the one last time, and I'm done in 2 minutes. His supplementary agreement, which he executed, which I showed to your Lordship yesterday, that is at page 10 of the additional affidavit filed by the petitioner on 18th of January 2024.
Which annexure?
Lord, it is annexure. It is annexure B to the supplementary affidavit, to the additional affidavit filed by the petitioner on 18th of January 2024. Your Lordship had seen it yesterday.
Annexure?
Annexure B. Internal page 10. There is a photograph of the gentleman.
Page 224.
18th January 2024.
Yes, it is there.
Yes. If your Lordships have these notes,
Yes.
kindly see. So, this document was registered on 30th of March 2016. Your Lordships have it in the very first line. Supplementary lease deed. This indenture made on the 30th day of March 2016 between the Governor of Orissa and the state government, which expression shall so and so, and so and so, And if my lords are kindly pleased to see 12, page 12. Your lordship may see the first line of page 12. Whereas the lessee leases have executed a mining lease dated 21st of February 1974. Now let us add 50 years to that. It will take us to 20th of February 1994.
24.
I'm sorry, 24. And that is the statutory prescription of 83. And that your lordships will get at page 13. If my lord Chief Justice is kindly pleased, note page 13, my lord Justice Das has it, page 13. Second paragraph.
Yes.
And
Yes,
yes. So therefore, my lord, this is a supplementary lease deed, completely in sync with 883. You accept it without demur.
yes.
Now you want to arrest. The statutory provision contained in 84 by saying that extended beyond 24, which is not permissible.
Yes.
And we have to force measure one FS or the covenant in the lease deed, your lordships have accepted in that RP South case that will have to yield to the statutory provision. Well, in that case, in that RP South case, there was a similar claim.
Yes.
His lease was granted by 2020 under 86. He said that, look, I have lost out on so many years. Please give it to me. Your lordship said no. Because that would run contrary to the statute. And as I have told your lordship, dolomite is a minor mineral. And under the minor mineral, there is no problem of it. I'm so sorry.
No, please stop.
I'm grateful to your lordship for a very patient thing.
Yes, do you want to add?
Word I will reply.
I will just
Most
come.
of the things not in my favor, I will reply one by one.
We'll just come back within 5 minutes.
So, which my learned friend raised, let me answer one by one. Your lordship was putting the last question. Let me begin with that. That is on record. There is no mining dues. This certificate was issued by the director at page 142. Your lordship would find. This is to certify that no mining dues is outstanding against Charles Jalan, 142 please. Your lordship was putting this question.
No, what is the date?
Lord, that is 23rd August 2012, when admittedly the revision was pending. Lord, let me just make the distinction, which is also the founding of the
Last paragraph. I'm sorry.
Yes.
yes. No minor dues, they said so and so is outstanding against the which is stayed by the court or any authority competent thereof so and so. So no dues was pending. That's not the case. So let you lordship may kindly look at the last thing. This divisional authority order. Please, Let para 11. That is very important. Let the confusion, in fact, was in the mind of the government. They wanted that since the renewal application is to be heard first. Let your lordship remembers there is a rule that if the application has been made for renewal before 1 year of the expiry of the lease period, then there is a due renewal until it is rejected. Now that is what is provided under Rule 24A. I made the application in time, the next page, that in 2013 before 1 year. Then the lapsation part, it could not take place until and unless the lessee is given an opportunity of hearing, the right cannot be taken away. That is the ratio of the common cause case, para 35, if your lordship would permit me, para 35. So it is neither a case of lapsation nor a renewal. My long friend is confused there, maybe the government was there confused. So it is neither a case of lapsation nor a case of renewal. It is a case of pure and simple resumption of the suspended application for the reasons that I didn't have the statutory clearances or I obtained, submitted 2012. They went on issuing the notice that you come on for personal query. That maybe for renewal below is by operation of law itself, it was a deeming renewal in law by Act 10 of 2015. So 50 years, I am not the sole person who got the 50 years because of the second renewal. People have operated for 75 years, 100 years also. For 4 million, there is a capping of 31st March 2020, like R.P. Shah and others, and the Karnataka batch of cases. I do not fall under the category of 31st March 2020 lessons. I am a machine whose use period is still alive, and that is up to February 2024. 50 years period, beyond 50 years period also there is a class. Captive sources, there is number 2 class. And below the non-captive places, they are another class. And there is a 4th class law, which who have been getting renewal after renewal, second renewal, third renewal, fourth renewal. By whose time this law says that there cannot be indefinite renewal. There has to be a cap somewhere. 31st March 2020 is the capping date. Beyond that, this non-obstacle clause will take care of which belong message. But my case is entirely different. It is neither under the Orissa Mineral Concession Rule 2016 nor under any other thing. It is pure and simple law, a grant under the MLBR read with the Mineral Concession Rule 1916, subsequently substituted by 2016 rule. It doesn't have any application because the third K law, which is the format of the agreement for execution of the lease deed, is a part of the Mineral Concession Rule that is exactly the agreement which and para 89 I read. And the supplementary agreement which was executed in March 2016, that says that the present deed also is a part of the extended part of the earlier deed which was executed. Your Lordship may kindly turn to page. That is in continuation of the earlier deed. This is not an independent deed. The 74 deed is the best deed. Thereafter, first renewal, etc. There is no second renewal. This is the first renewal. In my case, because 20 years by virtue of law, again it is 20 years, 40 years. Then the last amendment of 2015 by insertion of subsection 3 of 8A, it is for up to the period of 50 years. I am not on the dispute that it is for a period of 50 years. I am on a simple question whether I have really been given that period of full 50 years to operate. That is the sole question, Mila. 50 years, there is no dispute. The sole prayer before my Lord is that whether I have been given that full period of 50 years to operate. The answer is certainly no. And the supplementary agreement also, Milan, which was...
Then, Mr., in that circumstance, there would have been stipulation in the lease itself, in the last lease, that you will be continuing the mining work till completion of 50 years, adding that period during which you could not conduct the...
No, that is a general format which is in the statute book itself.
So that is
the format that they can say there also. They can utter a single word because first the format is prescribed under the rule. That is not the case, Miller. So therefore, I went before them in 2022, Miller, a cryptic order. Your Lordship knows, your Lordship can look at the government's order, impugned order 23, Miller. Your Lordship may kindly have a glance. A 3-line order. And my representation runs into 12 places with reasoning.
understood.
A cryptic order without any reason, explanation whatsoever, your Lordship knows, Governors Panji, they spelled out. It's a public order. By a public authority, it has effect on my consequences, several consequences. And the third thing, which my Lord friend advanced, 12FA. 12FA is akin to is in parameteria with form 3 and that part 9. That is below a part of the agreement. Your Lordship may kindly have a look.
Yes.
4K, the agreement part, That is not exactly the verbatim of para Kenya of the old rule. Same thing has been reproduced, the force majeure. So that 89 Delhi, which my long friend wanted to distinguish that 15 Act was not there, that was there as a part of Form K in the 1960 rule, which forms a part of my agreement. That came to be interpreted in Delhi, and that provision still exists in the amended rule of 2016. There is no dispute. So the third thing, Saul's case, below, I distinguished it, though this Delhi and the Supreme Court was taken note of, but Saul's petition, below, that the fact was suspended by the mining authorities because of unlawful activity, mining activity. Then will have this common cause case, SAR commission, so many things. He is under that category.
Okay.
And now there is no malfeasance. There is no allegation against me. There are three dates from the note submitted by my learned friend. There are only 3 dates I will point out. Just
So do you dispute any disclosure made in the list of dates?
I am just pointing out them. That will be useful for you lordship to note that. I was holding there. Let your lordship kindly turn to the third page. Fourth page. And one paragraph from the revisional authority, that I will conclude. Let this 7/1, 2014 serial number 18. A revisional authority, let it is his note. Disposed of the revision application of the petitioner, it set aside the demand of 2 crore under so and so. It further directed the state government to allow resumption of mining operation till expiry of such and such period. That 40 years period was the statutory period of 40 years. When my application was pending for renewal, this new law came, and that was deemed renewal up to period of 50 years. So therefore, they said that since by that time the law was not amended, which came into force only in March 2015. And my application for renewal was pending before the government since 2013. I'll be deemed to be continuing as a lessee under the government. And subsequently, the law took care of persons like me, those who are similarly placed, whose list was subsisting on that date of enactment of law. Let this order is of your lordship may kindly mark. At least I am entitled to the benefit of this period. 7/1/2014, the Government of India directed. They will not pass the order on 8/10/2015. Let serial number 20. State government wrote a letter to the for allowing resumption of mining operation of the petitioner. But I am asking myself, I fail to understand if the government of India, in the capacity of a statutory revisional authority, passes an order in January 2014, and there is no dereliction on my part or deficiency in my part. Why the state government will take another 1 year and 9 months to pass a final order? At least to this period, I am entitled in all fairness. Though not for 3 years and 10 months, but this is substantial a period which was.
Therefore, you should have approached soon after this 8/10/2015. You could have raised your grievance.
The court of equity, your lordship, as to if your lordship feels that there has been miscarriage.
It's no question of feeling.
I have
It's rights.
So it's a corruption of my right which has been artificially curtailed by the state authority, by the state action. So that the third thing, that your lordship may kindly even come.
If not earlier.
Well, it's, your lordship is right. So the execution of the supplementary leave doesn't stop me, Mila, to raise this claim and say that no, this period I'm liable to be compensated. Your lordship rightly put that question in Karnataka case, Justice Wakar judgment. They have said in the direction number 2 that he is entitled to compensation.
No, but there was specific relief sought in that case.
No, that's correct. No, they have given that. Even if not this compensation, I'm not going into that. Relief, even if it is not there, it can be somebody. But in Delhi case, they said that no specific relief will not in this such a situation where there are views which may differ. I'm not, but so far sounds concerned, it's auditor. It doesn't directly deal with the fact situation of my case. Sao is not a binding precedent. It doesn't fit into my case. It is a class of law which falls under the category of 31st March 2020. I am not a class belonging to that. I am on a different footing altogether.
Right.
And their minds were suspended by the lawful authorities, DFO, others, illegal mining. There is no such allegation against me. You sit over the matter, do not permit me to operate, and again say that because the 50 years period is going to expire and he executed the supplementary deal which still forms. That supplementary lease deed also, University President number 22. That was executed on 31st March 2016. I am entitled to 10 years. Well, I am in 2016 also, I am getting only 8 years period. Up to 16 million, I am getting only 8 years period. But in all whatever may be the arithmetic computation, whether it is 3 years, 10 months, or 1 year, 9 months, or 1 year here also, that is again falls short of 1 year, 8 months, 10 months. So I have been deprived of that lawful period which is statutorily granted to me. Not that I am asking for it without payment of.
You've been deprived of any period from the date of execution of supplementary lease deed.
That is 2 years.
No, from the
1 year, 11 months.
13/3/2016.
16 years, that would be 10 years. By this,
You have been deprived of any period from the date from the execution of this sale deed 33/2016.
up to now, I have not been disrupted. But I have been disrupted for this period.
We appreciate.
That's it. So that's all. I don't think that anything factually. But beyond fact, whatever the land advocate general explained, that is not the case. He was explaining something else which is not neither pleaded nor argued by the state government. Facts are very clear.
He has not made any submission.
He was submitting
Based on facts beyond record.
Odisha mineral concession rule has absolutely no application. So there is no question of any insertion of a clause in my agreement. I am fully guided by the MMDR Act 1960 and the rules framed thereunder. It was earlier 60 rule, now it is 2016 rule. Odisha rule was framed in October 2016. That is an exercise of power under section 13 of the MMDR Act, and that is entirely for different purposes. And this limestone and dolomite, it's a combination of these stones. It's a part of the major, part of this pillar, sorry, minor. So there is no question of applicability of two different rules to one set of agreement. They are bound by the agreement, the parties are bound by the agreement. Agreement clearly stipulates that these are the conditions. That the sum and substance of my submission is that whether I am entitled coming back to the whole period of 50 years. That's the question. That deeply applies for giving me present here.
We don't know what will be the result of the case. But the bench is thoroughly impressed by the way in which the case has been conducted by both of you.
We are grateful for
and the state. Grateful. So, thank you.
Great.
Heard. Mr. Acharya and Senior Counsel assisted by and Mr. General for the state of Orissa. Except on next Friday, 27 weeks, particular date. We will try to ensure that the judgment is delivered as soon as it is possible.
Since 28th is last day, I have also extracted mineral.
If you want, we can deliver the judgment on 20th.
No, that is after your I'm not.
Acharya?
No, but I only pray that nothing would, because my mineral, I have also 6 months moratorium period for removal of these stacked minerals. So status quo as on date till the delivery of the judgment be maintained.
No, interim order, we are not.
Why I am submitting now?
20th judgment. We will deliver judgment on.
Obliged. Grateful. Item number 2.
Before my learned friends begin, the Lordship is kind enough to permit me to file a short note.
Yes,
I
we were looking for you.
I'm sorry for this. I've just enclosed the CBIC circular and the Honorable Patna High Court judgment regarding this. Subject to your Lordship's thank
Have you pointed out the
I've tried in my
which are required to be made in
I have in my humble way not stated the statutory provisions.
Where is the Patna High Court order?
The Patna High Court laws I've enclosed
Page 6.
at page 6, running page 6 laws. Lordship Court?
Yes.
There your Lordship have noted the relevant Bihar notification at the end, it begins at the end of page 7, running page 7.
Yes.
It appears that conscious of the fact, your Lordship got it?
Yes.
It appears that conscious of the fact of non-constitution of the traveller, a notification dated 12/2019 for the removal of difficulties in exercise of powers under section 172 of the BGST Act has been issued by the state of Bihar. Clause 2 of the notification reads as follows. For the removal of difficulties, it is hereby clarified that for the purpose of calculating A, the 3 months from the date on which the order sought to be appealed against is communicated to the person referring the appeal. In subsection 1 of section 112, the start of 3 months period shall be considered to be later of the following dates. Date of communication of order, or 2, the date on which the president or the state president, as the case may be, of the appellate tribunal after its constitution under section 109 enters office. So this was the Honorable Patna High Court.
This is BGST.
This is BGST.
All right.
So unfortunately, in the state of Orissa, we do not have a similar act.
No, but there is a
There is a CBIC circular,
CBIC.
which I have annexed at page 11, my lords. I've extracted that in my note, and page 11 I've extracted it. You'll actually straight away come to paragraph 4.2 at page 13, my lords.
Just a minute.
So can I get a copy of?
Just-
Sure.
Okay.
I'm sorry. I'm extremely sorry. I've extracted the CBIC circular.
Please. GST.
This CBIC circular was on the subject, which your lordship would get at page 11, clarification in respect of appeal in regard to non-constitution of appellate tribunal regarding. That's at page 11. And if your lordship would come straight away to page 13, paragraph 4.2. It's in similar lines. Now just please.
Yes.
The appellate tribunal has not been constituted in view of the order of the Madras High Court in case of Revenue Bar Association versus Union of India and therefore the appeal cannot be filed within 3 months from the date on which the order sought to be appealed against is communicated. In order to remove difficulty arising in giving effect to the above provision of the Act, the government, on the recommendation of the Council, has issued the Central Goods and Service Tax 9th Removal of Difficulties Order 2019, dated 3/12/2019. It has been provided that though the said order, through the said order, that the appeal to tribunal can be made within 3 months, 6 months in case of appeals by the government from the date of communication of the order or date on which the president or the state president, as the case may be, of the appellate tribunal enters office, whichever is later. So this, my lord, the CBIC circular,
No, what is statutory is the central, this order
so
dated 3/12/2019 issued by the central government
manage,
in exercise of statutory power
manage.
of removal of difficulties.
Months.
So do you have a copy of this?
I'm sorry, I
This
thought.
Central Goods and Service Tax 9th Removal of Difficulties Order
I
2019. Do you have?
Your Lordship,
Must be there.
Your Lordship,
So in the line of that order,
Yes.
the Bihar government had issued, must have issued the
Your Lordship,
notification.
Your Lordship. Subsequently, 2000,
Whether it is missing in the file.
Bihar government has exercised.
Do you have a copy of the
Your
order?
Lordship, 19 notification, I have copy. And
Ninth Removal of Difficulties Order 2019.
so we'll get it for your Lordship. Your Lordship, but what the Bihar government 2019 CBIC notification? No.
Central government.
My lord,
Act order.
difficulties order.
Yes.
Well, what has happened in this case, the Bihar government was exercising powers under section 172 of the GST.
Of the
Bihar GST.
Bihar GST, BGST.
Minutes.
So similar power must have been exercised by the central government under similar same provision 170.
It's almost like the country. Minutes. Your Lordship, one thing remains clear that their Lordships of the Honorable Patna High Court, as well as the CBIC, they have accepted the fact that this 3 months has to be calculated till from the constitution of the tribunal or from the date when the president or the state president assumes office, whichever is later. Right. But that is, I don't think my learned friend of the tribunal dispute about it. That is the common link for
Very simple. We have to follow
manage.
the ninth removal difficulties order
Manage.
2019.
But your Lordship, the 2020 notification is in 2020 notification of Central Board of Indirect Taxes, your Lordship, CBIC. Clarifies between your Lordship.
In 2019 notification is 20 this letter
Your
is
Lordship.
simply a communication. Nothing. It refers to statutory order, ninth removal of difficulties order 2019.
Your Lordship.
So therefore, what we are required to quote in our order is
Your Lordship.
this ninth the provision under the ninth removal of difficulties order, which is statutory issued by the central government
Your Lordship.
under CGST.
Your Lordship, that is.
So we have a copy.
2019.
We will quote that instead of BGST. We will quote that provision in the order, and we will dispose of applications.
Your Lordship. But your Lordship, for better appreciation, your Lordship,
It is not, he is again leaving that.
2019. Yes, so I've seen it. I'm sorry I couldn't get it for.
Thank you.
And your Lordship, only what I think, what is the change required, only for.
Yes, please.
Only your Lordship, this is the order.
Yes.
Only a paragraph, page 3 of the order,
Page 3. Yes.
page 3 of the order,
Yes.
it's a 7 pages order.
Most interestingly, this letter.
What if that has been clarified by them, then we will grant that.
So,
Yes,
Your Lordship, at page 3 of the order, Your Lordship, I have handed over the order passed by
Yes.
the Honorable Patna High Court.
yes,
Your Lordship, page 3, the last paragraph.
yes.
Upon my humble submission, last paragraph, Your Lordship, the respondent state authorities have acknowledgement fact of non-constitution of the tribunal and combined with the notification. No, which will be place.
Which,
Page 3 of the Patna High Court's order in case of.
yes,
I have handed over, Your Lordship.
yes,
The last paragraph, page 3,
page 3
Your Lordship.
of the order.
Your Lordship.
It is apparent.
Respondent state authorities. Your Lordship, I have handed over the order. On the first day, I have handed over this order, Your Lordship.
Oh, this is another order.
Your Lordship.
All right.
Put it, the response, put it.
I have submitted on the first page. These three, last paragraph. So what is required to be said here, Lordship, as per my own submission, the respondent state authorities, your Lordship, have acknowledged the fact of non-constitution of the tribunal and come out with a notification bearing number so and so. So in this paragraph, your Lordship may put so far as the CBIC notification of 2019 and 2020, the later of clarification of 2020. So
The
Lordship,
respondent authorities have acknowledged.
your Lordship, state authorities have acknowledged, your Lordship, here, state government has not issued any notification as well as Bihar state, your Lordship. So we are abiding by central CBIC notification, CBIC guideline. So that is applicable here and that should have been, your Lordship, have put that in place of this Bihar notification, your Lordship.
Yes.
On my humble submission, wherever it has been written as BGST, your Lordship, in place of BGST, that should be OGST, your Lordship, in the entire order, Odisha Goods and Service Tax Act. It should be CGST also, your Lordship.
Should be, we will.
Still not GST, CGST, start with GST. Now, your Lordship, my kindly look into, that's, I would do it. Your Lordship have just quoted the given portion of another order in page 4 of 4. Page 5, your Lordship, the finding part. After my own submission, your Lordship, this court is therefore inclined to dispose, your Lordship, the last paragraph. This court is therefore inclined to dispose of the instant petition also the following parts. Subject to the benefit, here in this case, your Lordship, the 20% has been paid. For that reason, your Lordship has passed this order. The subject to benefits of the fact that deposit of a sum of equal to 20% of the remaining amount of tax is in dispute or deposit the same if you have already deposited. So in this particular case, the amount of 20% has been deposited. So since your Lordship is passing common order in all the cases, your Lordship, so your Lordship may clarify wherever it has been deposited or where not deposited, and to deposit within a specific period.
This will apply subject to verification.
That will be subject to verification. So Lordship, your Lordship,
Or deposit of this.
Or deposit of the same one. It's all right. On deposit.
Your Lordship, conditional order. Not common submission, wherever it has been deposited, that is not case. It is deposited.
This will, this
It's not deposit has been made.
If not deposited, some time.
why should? If they don't want to avail, they will not avail.
Then it's a question of
The only question, these applications involve is,
Your Lordship.
it's a circumstance where the tribunals have not been constituted. They have right to appeal under the Act.
Your Lordship.
So, there is clarification order issued by the central government
Your Lordship.
in exercise of statutory power.
Right.
So, upon payment of 20%, no steps shall be taken to recover the amount. And two, after the tribunal is constituted,
Your Lordship.
they can Refer the appeal. And the limitation period will start running from that.
Only my submission, what is that deposit? In this way, not deposited, because they have one here. For an period. You know, my understanding.
They have come here for an interim order. We are not passing any interim order. We are just disposing of, giving them liberty to deposit.
But deposit may be a stipulated amount. So the balance in this way, let me clarify. So the balance in this way not be fully but I believe.
Sir, if they don't deposit, then you may take steps.
The consequences are always there. Consequences are always there.
If you don't deposit, if they don't deposit, you will have the right to recover. That is the requirement.
Why I'm saying so, why I'm saying so, my lords, if your lordship will pass a general order, that will help in all the pending writ applications also. Because the lordship will specify dates and all that, that will become too cumbersome, and in each case, the lordship have to. That is not my prayer. My prayer is made it very clear, the subject to deposit of so and so, that there will be the other remaining balance. So if they have not deposited, the consequences would follow, my lord.
Yes, if they don't deposit, if they have not deposited and they don't deposit.
Only my confusion, your lordship, the confusion arises in my mind. That since the reputation is going to be disposed of by your lordship, and your lordship was disposed of the liberty to file appeal, and 20% is not deposited to deposit. Your lordship then to deposit further that will be indefinite period. Your lordship, but then it creates some confusion.
How can we convince you, Mr. Counsel, that if they don't deposit, you have a right to recover? You can exercise that.
There can't be tailor-made solutions for all problems.
And see, we are not commenting on anything, but there is a circumstance where the petitioners question the liability. And you say, all right, we will not get your liability, this thing adjudicated upon, but pay 20%, we will see later. So if you raise 5 illegal demands, then you are in a position to recover 100% without any liability. So you are in a very good position.
Not only 100.
There is no forum for adjudication. And you are taking 20%.
100%.
I have annexed the order in Angel Intricon.
Yes.
A learned friend has given it for Shapoji Palanji.
Say you have Angel Intricon has been followed in that case.
Some modifications, perhaps.
Some
I have given Angel, and my learned friend has given Shapoji Palanji.
Yeah.
And one small humble submission, lords, subject to your lordship's kind consideration. I have at paragraph 7, lords, I made a very humble appeal.
Yes.
Subject to your lordship's kind consideration.
Please.
That at page 5 notes of the note minutes,
Yes.
that further may be clarified that the GST portal shall allow filing of the second appeal without further demand of 20% of the remaining tax which has already been paid. Because what happens, my lord, in this case, that the portal sometimes does not allow filing unless you pay this 20%. So subject to your lordship's kind consideration, lordship may modify it in your lordship's.
We shall not go into that.
Okay.
Presently.
That
will amount to issuing certain directions at this.
I'll leave it to your lordship. I thought that would be a problem which may come up during filing of the appeal.
Come whenever such problem arises.
Your lordship.
Come, we will see.
As my lord dispose of this writ application, original first appeal order may have returned to file at second appeal, instituted of the copy thereof. Original first appeal order is filed with writ application. This may can be returned, it's a copy thereof.
Why?
Because the original first appeal, required to file second appeal, before second appeal. This original file, first appeal order filed along with this appeal, may can be returned.
Why should you? No, on that order. Yes, we will be passing an order and we shall not upload that unless both of you, Mr. Kar and Mr. go through the order and then we will upload that.
Your Lordship, I will be permitted. I have instructed my office and my office has prepared a list of the pending cases, Your Lordship.
No, we will not go into that.
No, Your Lordship, to be listed, Your Lordship.
All right.
Your Lordship, listing of these 450 matters so that all these can be disposed of, Your Lordship, the same order, Your Lordship. In all these cases, in some cases, 20% in all cases.
So this should be notified so that the land council was here in that case.
Your Lordship, my list is all these cases. A listing, Your Lordship, so that all these cases can be disposed of.
What we shall be doing is that we shall be notifying the list of such cases,
Your Lordship.
making it clear that these are proposed to be disposed of in terms of the order which we are passing today, so that all the members of the bar may have the proper intimation
Your Lordship.
that this order is may be passed in those cases. We are open to any submission which can be advanced.
Or Your Lordship, after passing Your Lordship's order, I can give this list after.
No.
Or subject to your Lordship's kind consideration, your Lordship may keep one small afternoon so that all these cases will be listed so that the parties will be here. And
No, not only that. We shall get these listed, these cases notified, they will go in your association also. So that and on the website, all right, that these are the cases which may be disposed of on the line of the order which we are passing today. All right, and then they will be listed on one single day and can be disposed of.
much obliged.
This is what we propose to do. How many land council are there in all 440 cases?
I think 2030.
2030.
Your Lordship, I am tax advocates, it is the cases about the tax advocates. Your Lordship, I am applying for the CBIC, Central GST.
Yes. You should be happy.
GST, Central GST.
You should be happy, the happiest person.
Well, I was trying to make a mention for people also, because I didn't have any matter today in this batch belongs. What I am suggesting, unless it is inconvenient to my friends belongs, if the pending matters, the batch comprising of about 450 matters, if those can be listed along with today's matter.
No, today we are disposing of these matters so that other matters can be disposed of on the same lines. Otherwise, it will become very difficult for us to.
All other matters, so many lawyers.
In fact, we could have disposed of one writ application. And that could have been, the order could have been followed in other cases also.
No difficulty. But I do not know exactly what is the
20% popular, balance team.
No problem.
We don't have a.
This is what we are doing.
Grateful note, I'm sorry for the delay. Give us note.
Oh, but we were looking for you.
Sorry,
Mr. Kar. We were looking for you on the last day. Sorry, Saleh.
Your Lordship, in the first matter, main matter, the department has recovered the entire tax amount. Entire amount has been recovered by way of collection. So it is not necessary for me to.
What can be done? You will file appeal. Still,
Yes, I will file appeal.
Subject to verification.
Subject to verification. Therefore, your Lordship, due to your Lordship's effort, your Lordship, all these 500 cases have been disposed of.
all these frivolous cases.
Your Lordship, since I have gone through your Lordship's order, and that is a nice order, for that reason I have adopted that order, your Lordship. Thank you, your Lordship.
that lessen the burden of my learned friend lots.
No, it is important to everybody. It is important to everybody, your Lordship, also to the court, because the tendency of 500 cases, your Lordship.
CGST. Please listen to the order which we are passing. Maybe slightly different from what is there in the Patna High Court. See. This is not in dispute. It is a hurdle and consensus. It is not at all in dispute that the orders impugned in the present writ applications which have been passed by the authorities under Central Goods and Services Act 2017 / Odisha Goods and Services Tax Act 2017 are applicable under section under subsection 7.
112 notes.
Under
Section 112, section 112 notes.
Under section 12. Under section 112 of the CGST / OGST Act 2017. First off, it is also not in dispute that because of non-constitution of the appellate tribunal. Where is the constitution?
109 notes.
10. Appellate tribunal stipulated under section 109 of the said acts, the petitioners are deprived of their statutory remedy of appeal. And the corresponding benefit of subsection 9 of section 112 of the said act. Is it correct, Mr. Stop. The petitioners are desirous of availing the statutory remedy of appeal under the said provisions. Stop. Apparently, acknowledging the absence of constitution of appellate tribunal, comma, in exercise of the central government. That central government. The government of India, comma, in exercise of the, where is that? In exercise of power conferred under section 172 of the CGST 2017, based on a recommendation made by which council is that?
GST Council.
Made by the GST Council.
GST Council.
GST Council has issued Central Goods and Services Tax bracketed 9th removal of difficulties. Order 2019, clause 2 of which reads as under. वो कर दो इससे। What's up? In tune with the said क्या लिखा? 3/12/2019 for a sentence from Government of India.
Based on the requirements of the GST Council.
On 3/12/2019. It reads as under. In tune with the said the removal of difficulties order dated 3/12/2019, comma, the Central Board of Indirect Taxes and Customs, comma, GST Policy Wing has come out with a clarification in respect of appeal in regard to non-constitution of the appellate tribunal. Paragraph 4.9 or 4.2 of which is relevant and is being reproduced herein below. उसमें करो 4.2 and 4.3 which are being reproduced here and below. So stop. Taking into account the aforesaid 9th removal of difficulties order issued by the Government of India dated dated 3/12/2019 and subsequent clarification issued by the Central Board of Indirect Taxes and Customs bracketed GST Policy Wing dated 18/3/2020, comma, we deem it proper in the interest of justice to dispose of these writ applications with following observations. And dispose of these writ applications in following terms. So stop. No, following terms, colon dash. Then this we can mention
Manoj,
without any.
Shapoorji Palaji, your lordship can extract notes. So that your lordship would get it at
Yes.
internal page 5.
Internal page 5.
Manoj, Shapoorji Palaji.
Last paragraph.
Last paragraph.
BGST.
Instead of BGST, your lordship have to modify it. Shapoorji Palaji.
वो भी ये BGST जो है ना, इसको GST का तो period applications stand disposed of. और टाइप करने के बाद वो प्लीज गिव a copy to senior counsel and ठीक है. We will make a copy of the order before it is uploaded. It will be uploaded today itself.
Madam, I'm appearing on behalf of the state GST, Standing Council of State.
Please give your appearance.
Yes.
Lord, so kar do.
Appearing from the central GST. Right. Get
Lord, so kar do. सबका नाम दे.
Bring your place.
appearance and so on. Item number 3.
Item 3 on behalf of Mr. Pandamera can taken on next week.
As requested on behalf of the petitioner, list this matter on 1 week.
1 week after. Because he has faced some accident last month.
Accident?
Accident.
What happened?
On road accident. Leg
Fractured?
fracture.
Fractured?
Yes.
And how can he come after 1 week?
1 week.
1 week, how can he come after 1 week if he has got his leg fractured?
Simple,
1 week के बाद कैसे आएंगे वो?
simple fix. 1 week after.
हाँ?
As your lordship pleased.
4 weeks, check.
Item number 4. Well, it is that matter. Yesterday it was there.
Yes. What is your submission?
I will just come up with a small note.
You will write the order.
But I was stuck at a point yesterday that what was my stand before the at the time of seizure and now. But there is some development is there, which I will explain. You will also kindly see the
No, first of all, let us know what is your stand, because under the provisions of the Act, The goods are to be returned to the person from whom this is,
from whom possession was seized. Right. My lords were pointing out that the petitioner number one has stated that it was not possessed by me and the department people have planted it with me. So that was the stand your lordships were pointing it out. But the difference is the petitioner number one is not claiming, he is not the petitioner here as his own, in his individual capacity. His father was the person from whom the seizure took place. The writ petitions, all these developments cases were going on, and during pendency of this case, he died. So in this case, the petitioners are the legal heirs of the father of the petitioner number one, from whose house the entire stock was seized.
very difficult. Very difficult.
By your lordship kindness, I will just take your lordship to one or two pages. Your lordship see the cause title. There are 6 petitioners who are sons and daughters of one Janardhan, one Jagannath Swami. Janardhan Swami.
They will be bound by the stand which has been
And
taken
it's-
by their father.
Annexure 1.
So according to you, their father was required to be convicted. So he was wrongly acquitted.
Not that. That's why I have given to explain that, because let me not also be confused. Therefore, I have given, what has happened under section 85 of the Gold Control Act, the petitioner number one was asked to be prosecuted because he was possessing gold. Your lordship knows under section 85, a criminal case can be initiated if a person possesses or control.
Yes. Please.
Right. Section, the Gold Control Act prohibits any person from possessing primary gold. The primary gold has been defined that if it is more than 9 carats. So if anybody possesses gold, primary gold, he has violated the provisions of the Act. Section 71 states the gold can be confiscated. But the rider is, he must be given a notice to show cause. And he can be prosecuted under section 8. That proceeding under section 85 for possessing or violating the provisions of this act was initiated against the son of the owner, that is the petitioner number one. My father was a licensed dealer. He is permitted to possess. Now, the possession is not an absolute prohibition, but a goldsmith can keep the possession, a dealer can keep possession, because others will give the gold and he has to possess. Otherwise, the functioning will not be there. So, if a prosecution was started against the father for not accounting for property, that is under section 87 and 88 of the Gold Control Act. That accounting was there.
No, this was your plea that in fact it was planted.
No, that is what I am trying to clarify. Prosecution was started against the petitioner number one under section 85 for possessing the gold. Prosecution was started against the father of the petitioners, saying that he has violated section 87 and 88 of the Act for not properly maintaining the accounts because he was a licensed dealer. If some goods are found
We can understand, sir, you are not required to repeat that.
Right, I'm sorry. So it was, the father was acquitted. Son was convicted. The petitioner number one was convicted, saying that although he has taken a stand, that it was planted in my hand, that was not believed, that was not accepted, and it was held that it was found in his possession at that time, and he was convicted. Then he filed an appeal, revision, all those things, and in the revision on technical grounds, he was acquitted because no sanction was there and all those things. But the factum of possession remained as it is. Now what has happened, when the proceedings were continuing, when Caesar was there, we could not appear before the adjudicating authority. An ex parte judgment was passed confiscating the goods. Then we filed appeal. At the time when the appeal was pending before the administrator, then this provisions of the Gold Control Act were amended and SAGET was established, tribunal. So all the cases were transferred to the tribunal. Tribunal has passed an order saying that the appeals, there was a reason for not appearing, and therefore remanded the matter by saying that within 6 months you please dispose of the proceedings. That was not disposed of. 18 years after, when stipulation was there that only 6 months time was given, 18 years after, notice was given to me. Then 2 notices, one to the son and also to the father. We are now on the case where the father's case is being dealt. Because in the meantime he died, as legal heirs, all the sons and daughters are before our lordships. Therefore, we will have to examine, and your lordships will also consider what was the case of the father and what was his stand. That is only to be seen now. Although the sons are there on record now because of the death. So far as when the notice came, as I was submitting yesterday, the father was suffering from dementia at the time when the notice was received. Then his son appeared along with the Vakalatnama of a lawyer, that's me only, appeared and said that he is suffering from dementia and therefore an opportunity. We don't know about the case or details. Please give the papers, we will take. The adjudicating authority took a peculiar view that if he is suffering from dementia, he doesn't know how he has put the LTA. He has got loss of memory. How could he put the LTA and how the Vakalatnama will be accepted and rejected the Vakalatnama? Then we came to the dishonorable court, saying that for after 18 years notice was given, section 79 clearly prohibits that notice should be given within 6 months, failing which goods are to be returned to the person from whom it was seized, and therefore the proceedings should be quashed. The Council for the Central Government appeared here. They took time and it was posted to a particular date, 13th January 2014. On that day, when the case was posted for them to take instructions and give this, same day, judgment was delivered there. Again, confiscating the goods without notice, without any appearance. Suppose your lordship knows the position, if at all a person is suffering or is minor or other things, court could have appointed a legal court guardian and matter could have been dealt with. Nothing was done, simply adjudication was there, again confiscating the same order, repeating the same thing. Then we filed an application for amendment here, introducing that judgment, because in the meantime of subsequent development, this judgment needed also to be quashed. This honorable court, instead of this honorable court allowed the amendment and said that you please file a better application charging all these things. That is how this present writ application has been filed.
So far as son is concerned, this, when was that order passed?
That order was passed in 2016/5/23. 16/5/2023. 16/5/2023. I filed this case on 21/6/23. So far as son is concerned, he has also proceeded in the same footing. He filed another requisition. That requisition was also disposed of by saying that in the same way. And in this subsequent requisition which he has filed, this honorable court took a view that since appeal lies against the final adjudication order, why you will entertain this in the requisition, and liberty was granted to him to file an appeal. My submission before this honorable court is,
He filed an appeal.
he has not filed an appeal, he wanted some extension of time, therefore filed a review petition or something like that. And
It is going on.
now the question is, on the face of the record, on the admitted facts, no notice was given within 6 months. Last trailer comes to the rescue by saying that if the notice is not given within 6 months, moves are to be returned. Even if it will go to the adjudicating appellate authority, the same point will be asked.
We will hear him. I wanted you to write this. All right,
Seeking personal but the entire process in the very beginning. So we should be given this to them.
anything?
But here, as my seniors very case of it said, there was similar order. This honorable has passed order to file appeal before this stay at not. So he has challenged, ultimately he has challenged the order of the adjudicating authority.
So where is that order passed by?
That is not, that is, he has, kindly see the date chart given by my senior.
No, where is the order?
I mean, I'll supply it, I'll supply it.
Please supply.
Put it up, today it's not there.
Please provide, we reserve the order.
I will also please. I'll provide.
Heard.
I try to submit today in no. But today gives a couple of decisions which on the field that within 6 months. So it will not.
You can give that.
I will just. I have mentioned in the note. I will just give the copies.
Heard, that also. Order is reserved.
Bolo. Okay.
The copy of the this IE for modification has not served on me.
Just
It is
additional. I
Just
just for a modification that the additional commissioner Balasun has been wrongly modified because now the additional commissioner consolidation and settlement is functioning at Bhadra. So that should be modified at the additional commissioner consolidation and
Which order? Which order?
my lord.
You want modification of an order?
Yes, my lord.
Which order?
9/7/2021.
Order number?
Order number 10.
Just a minute.
14.
Yes.
So, the additional commissioner, initially it was disposed of with a direction to the additional commissioner Bhubaneswar. But at that time, while passing of this final order, the additional commissioner was functioning at Baleshwar, taking the jurisdiction of the Bhadrap district.
Just a minute. Just a minute. Let us understand this. Which part of the order you want to be modified? Which
Paragraph 5.
five?
Paragraph 5 and 6.
Just a minute. So what kind of modification?
I want that the additional commission settlement and consolidation of Bhubaneswar for Bhubaneswar disposal in accordance with law, that should be the additional commissioner of settlement and consolidation of Bhadrap.
Bhadra. In place of Bhubaneswar, it should be Bhadra.
It should be Bhadrap.
Bhadra.
Yes.
Bhadrak or Baleshwar?
No. Baleshwar, after I have also filed another modification.
Two
But
modifications here.
yeah, thereafter the government has already transferred that case and separate commission has been office has been established at Bhadrap.
So when was that done?
My lord,
When was that done? Why? When did you file your modification petition?
this is filed in the year 2023, the present application. But first one was filed in the year 2021.
Is there any? Authority changes, we will have to modify the order again.
So what happened?
After council, wherever the,
2021 it is when we should have come from, please.
there are two things. One, there may be typographical mistake or place wrongly mentioned.
No, at the time of filing of this writ of
This was correct.
the additional commissioner Bhubaneswar are functioning and sitting about the matter relating to the lands of Bhadrap district.
Yes.
Accordingly, order was passed, but it was not within our knowledge. Subsequently, the party came that already the commissioner is functioning at Baleshwar, having the jurisdiction over the Bhadrap district. But when that modification was passed, thereafter again the commissioner was functioning at Bhadrap district, having the jurisdiction of that district. So this is the second time modification for election to the additional commissioner.
For the state. Why is this happening?
Government is
Have you served a copy on the state? No.
yes, yes.
You have not served a copy on the other side also.
Copy for
Because in a private party also no.
But this is your court, additional commissioner.
No, but that, there's to give us a copy.
Well, what he says, it has happened twice, so better we get a confirmation so
Let
that
a
it doesn't
copy.
happen again.
Of the. This appeal was filed in 2008.
yes.
This appeal is of 2008. Your application is of 2022.
23. This modification was filed in 2023.
Let a copy of the modification application be served upon and state council today in the course of the day.
Yes, yes.
So stop this matter on next Friday. Next Friday. Yes,
Also, the copy may be served on me. I am not the respondent.
for the state and the private correspondent. Do you have any objection to what he is saying?
That's all.
After taking instruction, I can.
No, if you don't have, all right, we'll see.
Orally also, I mean, you can take instruction without the copy also, because I've heard what has happened.
We'll see.
Item number 2. May I please let's
Yes,
that is the application for bail in a criminal appeal.
this is application for
Bail, my lord.
bail.
My lord, this IU number 979 2022.
Yes, what happened?
But here the petitioner is in custody since 13/12/2012. When convicted for the offenses under section 492, 304B, 302, and 406 35 against the trial, ultimately was convicted.
When was your application rejected?
Yes, the
Last.
application was last rejected 21/10/2020. Before that, appellant number 2 was released, my lord, was released. There are 2 appellants. One appellant is released on bail.
So you are the husband.
I am the my lord brother-in-law.
You are in custody for 12 years.
No, he's the husband. No. How just hanging? Yes, husband, sir. Husband. They both have, I went to the relationship 12 years.
Then we can hear your appeal. Finally. Whenever you want.
Let's please to fix let's.
Huh? If he has remained in custody for 12 years and he has not been allowed bail, then we can hear your appeal.
Let's please. But in this case, there is no eyewitness. And
All right, that we will see.
and another person has been acquitted while facing the trial.
We will see.
Why are you saying that you are the brother-in-law? Your
Yeah,
husband?
The
Yes,
relationship,
all right.
relations with the appellants. I wanted to, but I didn't follow the relationship with the
IA number
appellants.
979. What is the IA number? 979 of 2022.
Yes, sir.
IA number 979 of 2022. This application has been filed on behalf of the appellant number 1, seeking suspension of sentence and his release on bail during the pendency of the appeal, mainly on the ground that the appellant has remained in custody for nearly 12 years and in ordinary course, there is no likelihood of this appeal being taken up in near future. So stop. Next. Considering the long incarceration of the appellant, we are of the view that instead of taking up the petitioner's claim for suspension, appellant's claim for suspension of sentence, it would be proper in the interest of justice to expedite final hearing of the appeal. So stop. List this appeal for final hearing on. Can we take up? Why 4 weeks? Because paperwork has to be prepared. Paperwork is not ready.
But
The public not blood.
state order was for early disposal.
Yes, sir.
Nothing has been done, you sure? Let me check.
That is not so.
Nothing has been done.
This appeal for final hearing before final hearing on 4 weeks.
As you lordship. A register will directed to bloods, prepare the paper book and
What is paper book?
paper book will say all the documents that is
Which document you don't have?
everything is there, blood. It's a practice.
It's a formality.
Yes, yes, madam. That is the formality.
Sorry, we concern is formality, but state doesn't have that you have evidence.
A state doesn't have evidence.
No, because they supply only copy of the document. They don't
Still.
appellants don't supply the copy of the evidence. So you always prepare the paper book so that we can.
The original records are here. Original records can be there with you.
No.
He is having all the original records.
The records are with your lordships only, not with us.
Whatever is there before your lordships is there before you also. For everyone.
Anyway,
There is a question, let the paper book be prepared in the meanwhile. All right. Expedite.
The physical records, like the notice says it has been digitized and that ECR has been sent to the land court. The exhibits and all, otherwise it has been scanned. We have to scan copy here.
What is it?
Physical records do we need? We don't have to call for it.
Physical record should be there.
No, it had, after digitization.
Yes, these days, my lord.
We can make you are also available the revised copy.
Because copy is available, we can argue the matter. No need of making any paper book.
Paper book will be prepared for your benefit. Let the paper book be prepared in the meanwhile. Paper book they can prepare on the basis of what
Yes,
is
yes,
there.
it will be easy in fact, because it will be digital, it will be easy to. prepare.
Everything.
So, my lord, to clarify, I will not follow the relationship. I have to say the relationship of the both applicants are brother-in-law and sister-in-law. That is why I couldn't follow. I may be excused. Because
Half right on, the two appellants.
both applicants are related to a brother-in-law and sister-in-law. That is why I couldn't follow. So I may be
Okay.
grateful for that. Item number 3.
The appellant was interim application. Let's say interim application for bail on appeal. The appellant is in custody for about 11 years or 7 months. He is in custody since 14/7/2012. And allegation that he is the deceased is the maternal uncle while they are coming from market to get a single blow on his head.
These are such cases. In that case also, the appellant was there in custody for 12 years.
My lord.
You are there for 11 years. So let me have the data from the, depending upon the period of incarceration.
My lord.
We will try to expedite final hearing of the such appeals where the period of incarceration is say more than 8 years or then more than 9 years. Because we will take up the matter on the next Friday. All such matters shall be taken up on next Friday, and in the meanwhile, I'll have the data. Right, for expediting hearing on the basis of the period of incarceration.
But my case will cover, at best the case would be under 304 part 1. Even
Exactly, so
It will say
time in custody, you will get the decision.
custody is more than 11 years. Yes.
We'll consider.
And that was also the order by your lordship that 5/4/2021 was directed for hearing of.
Exactly.
Early hearing.
So, no hearing could be,
So here. paper
no hearing
are
could be
ready.
taken, now it is 2024.
Either we will hear your appeal or we will suspend the sentence. This we can assure you. All right.
Yes. And my paper book is also ready.
Paper book is ready.
It's ready, everything.
Matter on next week, so as to consider fixing a date of final hearing. Date for final hearing of the appeal. Yes,
Next Friday or?
next Friday.
item number 4.
Because appeal against submission under section 302 and Arms Act in custody since 13/9/2011. Last application was rejected in the year 21.
All right, same order.
Paper looks ready.
Same order.
Next Friday.
Next Friday. In the meanwhile, we will collect data from the registry
No.
and
Well, we are so fast.
Huh?
1 week makes no difference.
1 week makes no difference.
After 12 years.
After 12 years. Yes, you're right.
Item number 5.
Authorized
In this case also long incarceration, 7 years and a half.
Next
Like,
week. 7 years
covered by losses rule.
covered by your losses zero.
I was abided by losses rule for hearing of the matter, the long incarceration, 7.5 years. And the case under section 302.
We will see. Next week.
But that is ready also.
Item.
That exactly number I don't have, but different benches have been assigned depending 10 years, it's 2010 to 2015, different.
Item number 6.
Excuse me, my lord. I have filed IA to order the IA. Permit to order. Yes, sir.
IA. Dismissed as not pressed. IA number?
313.
Yes.
Item number 7.
Order the petitioner number 1. He happens to be the husband and his parents, they have been granted bail. My lord,
So you want them in jail?
my lord,
You want them to be in jail?
my lord, 6 years going to be completed and 10-15 days are left.
6 years, nothing.
6 years going to be.
So your prayer must have been rejected earlier?
Yes.
Yes, my prayer was rejected earlier on 9/10/2020 and thereafter by order dated 30th September 2022, my parents were released by my in-laws.
So you want that to be modified?
My lord, I renew my prayer in view of my income.
You can renew your prayer after you complete 7 years of your sentence.
My lord, under section 304B of IPC, my lord, I have been convicted, but there is no charge framed under section 304B of IPC. And under section 302 of IPC, my lord, I was facing the trial and from that charges I have been acquitted. Along with,
So what is more serious, 3(4)B or 3(2)?
but 302, my lord, I have been exonerated.
So which charge is more serious, 3(4)B or 3(2)?
My lord, 302, my lord, is more serious.
All right.
But the maximum sentence under section 304B, my lord, is life imprisonment. Minimum is 7 years. And maximum sentence was awarded in this case, but there is no, I beg to place with your lordship that there is no extraneous circumstances to invite a life conviction, my lord.
Granted.
This is the case where you will be beaten and then burnt. Is
No,
that
my
the
lord.
case?
Say, wife fell into an well. That is the prosecution says that she has been pushed to the well. Dead body was recovered from the backside of the house.
After having convicted of the offense punishable under section 304 capital B of the Indian Penal Code by the impugned judgment passed by trial court so and so for the appellant number 1.
Yes, your lordship.
The appellant number 1 has remained in custody for nearly 6 years.
6 years.
This appeal has been filed in 2019. Your prayer was earlier rejected.
Yes, your lordship. 9/10/2000.
This application, what is IA number?
Present I or
Double
Previous-
6.
This application has been filed for suspension of sentence and the release of the appellant on bail during the pendency of this appeal. Stop. Then counsel appearing on behalf of the appellant has submitted that the trial court has imposed maximum for the said offense, though there was no such circumstance as to impose the maximum punishment. Stop. He has also argued that there is no chance of the appeal being taken up for final hearings in near future. Stop. Next. It is noted that the appellant's similar prayer for suspension of sentence was earlier rejected twice or once?
Once, my lord.
Right.
Twice.
No, my lord, once, 9/10/2020.
30th of September 2020.
30th September 22, my parents,
For the in-law.
parents were
Allowed to
sir.
go there.
Earlier rejected.
In that application, I was not involved.
Address us.
Fine.
Please address us. We have to pass an order.
Yes, sir.
He cannot do anything.
My lord, I will listen.
Was rejected in 2020.
Compliment.
2020. So, taking into account the circumstance that the appellant has been convicted for the offence punishable under section 304, capital B of the IPC, and there is no evidence to the effect that is there any allegation that you had killed effect.
My lord, there is no direct evidence, allegations are omnibus, my lord, the parents of the deceased as well as the brother. All those,
See,
they have not
there are two circumstances. One, you killing the deceased, and two, the deceased dying and there being evidence of demand of dowry or torture. So these are two circumstances. So in the second case, based on presumption, you are convicted, and in the first case, on the basis of evidence of killing, you are convicted. So what is that?
My lord, on presumption, I have been convicted. On presumption,
Because there's no eyewitness.
That the appellant's conviction is based on presumption contemplated under section 304, capital B of the IPC, and he has remained in custody for nearly 6 years, there being no likelihood of the appeal being taken up for final hearing in near future, in our considered opinion, a case is made out for suspension of sentence and the appellant's release on bail. Stop. IA number so and so is allowed. What are the terms and conditions? Yes.
Item number 8.
if it not his lordships. If it not his lordships. The petitioner was that appeals this honorable court for in the matter of writ application for habeas corpus, restoring his biological child from the opposite party number 3 and 4. Thereafter, on 24/2/2021, the Honorable High Court has given an order in the favor of the petitioner, directing the opposite party number 3 and 4 to restore the custody of the child, namely Mrinal Thakur, Karma Bond.
Lordship, thereafter, after the 20, the custody of the child was restored on 26/5/2022. In the order dated 24/2/2021, there were two paragraphs, paragraph number 15 and 30, whereby the Honorable High Court has directed that the petitioner should get the child and go to Puri, which is to the residence of opposite party number 3 and 4, and in order to assurance the well-being of the child. So on the date of while taking the custody, the petitioner was threatened by the opposite party number 4, wherein I have quoted in the IA
What is?
that I will kill you if you ever visit Puri again.
So, in custody of the grandparents. So we have filed this, because you say, asking for custody of the parents, so
Who is
legal dependency with the father.
Hmm.
He stays in.
Age of the child.
As well date, he must be 15 years worship.
Class 9 in 2021.
Yes, worship. The date must be fixed. The petitioner is residing in Israel, your worship. So he is,
Israel, okay.
the petitioner,
Says he's staying in Israel.
He is staying in Israel.
yes, worship. Petitioner, only the petitioner, the child is with his grandparents at Kolkata. If a date may be fixed, he will be appearing with his grandparents, your worship.
We can take up in chambers. IE number 24 of 2022. 24 of 2022,
Yes, worship.
Yes.
considering the nature of modification which the petitioner is seeking, we adjourn the matter to who will produce?
His grandparents, your worship.
To next Friday. When the petitioners are ensured
You have filed it, your worship.
No, have you served copy on the other side? Because there was somebody appealing for the other side.
No, your worship.
The class and associate.
Yes, we have the copy. We could not contact them, so we haven't served.
The phone numbers must be there, so you can try, otherwise we have to send notice.
but in disposed of matter, why should we interfere? Why should we entertain a matter which is already disposed of?
For the well-being of the
Myself, I was under the impression that it is still pending. So disposed of matter.
Now, opposite parties are not.
They won't come.
Not,
The child is their parent.
not, we will not revive it. By filing IA number 24 of 2022, the petitioner seeks to modify this court's order dated
24/2/2021.
24 to 2021, passed in WPCRL 110 of 2019. Post of by the said order, the writ petition was disposed of. First off, we see no reason to entertain this application in a disposed of matter, which is accordingly dismissed. Yes.
Item 9.
grateful worship.
Right, legal.
But the appellants have been convicted under section 498A
302 and 301 IPC and section 4 of DPI are sentenced to undergo RI for life, my lord. My lord, now the present application for bail.
What is the offense?
Offense, my lord, 498A, 302 and 201 34 IPC and
Yes.
section 4 of DPI.
Yeah, they have assaulted and gone. for-
Because the court cannot grant you bail. The Supreme Court says that in such matters, the court should not. Sorry.
Letter can also be hard because we are also for instruction of the matter hearing was going on. So letters can fix this.
No.
Hearing also.
Yes, sir.
Now the present application for bail, my lord, earlier bail petition was rejected on 19/1/2021, my lord.
Maybe.
While granting bail to the respondent number, appellant number 2, the bail application of the appellant number 1 was rejected at that time. And the conviction also based on the circumstantial evidence, my lord.
Mr. Counsel, the Supreme Court says that once conviction has been recorded, the appellate court should not suspend the sentence. This is the Supreme Court's latest decision.
Since 5/11/2019 and prior to that 1 year, and during trial he was also on bail, ma'am.
Or we cannot go back to that stage of trial.
Since your lordship had kept other matter to Friday, let it become a Friday.
Not on this one. The petitioners, appellants, prayer for suspension of sentence.
Appellant 1.
Appellant number 1.
The prayer for suspension of sentence of appellant number 1 was earlier rejected by an order dated 19/1/2019. 21. By making this application, the appellant number 1 has renewed his prayer for suspension of sentence and his release on bail during the pendency of the appeal. After having seen this court's order dated 19/1/2021 and considered the submission advanced on behalf of appellant number 1, we see no reason to. But why the matter has been placed before us? Oh, so right.
Yes.
No, I thought.
No, no, this is.
We see no reason to take a different view than what was taken earlier in the order dated 19/1/2021. There is no change of circumstance requiring this court to entertain the appellant's prayer, for the present. IA number so and so is accordingly dismissed. Excellent counsel for the appellant shall be at liberty to take steps for expeditious hearing of the appeal.
Item number 10. Item number 10, my lord. Second copy of the brief is not filed. In course of the day, I will file, my lord. Second copy is not filed, my lord.
You have to list it. Where you should file a IA.
We have the digital set of copies necessary.
You don't fight. We exempt you.
Only the modification of error, my lord. But the IA copy I didn't receive. Let them serve a copy of the same only. Because,
So what is this about?
Hearing, my lord, London Central Government Council submitted that there is an anomaly committee.
10.
Yes.
There is an anomaly committee, but there is no such committee exists. My prayer is direction may be given to any other opportunity.
Mr. Raut, just look at that information which you have got under the RTA Act. Does it mean that it doesn't exist or it has, has not had a sitting? Just check.
No, my lord, page 7.
Check,
Annex
check, check.
10, clause 2. Clause 2, no information on decision of a departmental anomaly committee on civilian education instructors.
Which page?
Page 7, my lord. 7 of the interim
The
application.
IA.
7 of the IA.
Interim application, IA, my lord.
Yes. What is that?
There is no anomaly committee exists, my lord. As per their information.
Not exist, decision. With the difference between committee existing and decision.
By the unnecessary. During that period, whatever instruction I received, I pressed this code.
No, but
Subsequently.
relying on whether what he.
My lord, you must make I say page 7.
Yes, page.
Envelope. It is returned.
What is the given?
Page 7, no, information, page 8.
No, page 7, no, page 5, my lord, page 5. The envelope, the letter was returned.
What is page 8?
Nobody received.
What is page 8?
Page 8, my lord. I don't think that any post of anomaly committee in the ministry. Master.
What was the order passed? What was the order passed?
This anomaly was directed to the anomaly committee to decide the matter.
So they, according to you, there is no anomaly committee.
Anomaly committee.
Pay anomaly committee.
My lord.
So pay anomaly committee, how can there be pay anomaly committee after the work is over? After the function of pay anomaly committee is over, there cannot be any pay anomaly committee.
Any other authority may be directed, my lord.
Huh?
Any other authority may be directed, my lord. That's why I am said that let them serve the copy of the IA. I take the instruction. That is not being posted.
Instruction, what is the alternative? The disposal
Get
of
a
fees
copy of the IA number 16908. 16908.
Yes,
Yes,
my lord.
1690.
2021.
2021, yes.
We served on Learned Council, Learned Deputy Solicitor General for India in course of the day for him to seek instructions.
I follow.
Yes. To progress this matter on 2 weeks.
It's coming up after 3 years, even if there was any committee must have gone by now.
There cannot be, it's the job there of that committee is over, must have been over long back.
I don't know. Item 11.
Here there is a memo to withdraw the review. They file a review, there's a memo to withdraw that.
Item 12.
Logic. In this matter, I'm appearing the petitioner in both the tag matters. However, we have received no instruction from the petitioner filing a memo to that extent.
Learned Council, you don't have any instructions.
No.
And counsel appearing on behalf of the petitioner states that he does not have any instructions to press this application. So this application is accordingly dismissed as not pressed.
Nata tangal kalippo.
Memo.
Name tang nata.
It is your memo. You have signed this.
You hold power. Have you signed the Wakalatnama? What is your name? Yes,
Memo taken on the board.
Item 13.
there are two matters.
Please, madam. The noting is, the interim application copy has not been sought.
WP.
WPC 39523 here, they are given some fake certificates, fake documents. This is again a disposal of case. About the collector has been asked to take, so that they want modification that no inquiry should be held.
Petitioner.
So you want modification of which order?
I want to, in my interim application, I have to withdraw an annexer.
Withdraw annexure.
One of my annexer I want to withdraw. That is my interim application.
So if you commit a theft and return the stolen amount,
No, my lord wanted to know the original copy of that one document, my lord. That is a rent receipt only, my lord.
how can you withdraw that?
I want to not place that annexer.
So the writ petition was disposed of.
No, no.
So after disposal, you don't want to press.
No, that I have also filed the restoration application. That is also pending, my lord. That has not been listed today.
Restoration of what?
A restoration of the dismissal order. Application is dismissed for non-prosecution.
So both have to be listed
On part
together
of-
then. I don't know why they have placed it dismissed for default.
This cannot be listed because this matter has been dismissed. All right, unless your restoration application is heard finally, this matter cannot be taken up. So it will not be listed.
And my restoration application will be listed. That is pending.
Take steps, make a mention,
No, no.
not now. As requested on behalf of the petitioner, list this matter on. 4 weeks.
Item 14. Item number 14.
Item 14, madam, I'm appearing through VC, my lord. There's a
Please.
letter,
Yes, what do you want?
my lord, a letter has been received with your lordship's file, my lord. That is the noting, my lord,
For extension of time.
my lord.
For extension of time.
Let's see.
For
Indeed, my lord. My lord, the district judge Kota has requested for extension of your lordship's.
That is at page 69. Yes, yes, yes. So we had directed for disposal within 3 months.
Indeed, my lord.
So to what time should be granted further?
As your lordships please, my lord.
For 3 months.
For 3 months.
If granted, we can grant some because he says the parties have not filed their documents also.
Considering the communication dated 18/11/2023.
Yes.
18/11/2023. Addressed to the Registrar Judicial of this court by the Learned District Judge Khurda and Bhubaneswar, the order passed by this court on 22/9/2023 in WPC number 22790 of 2022 is modified with an observation that let LA bracketed NH miscellaneous case number 367 of 2013 be disposed of.
Yes, not
Be
give a date also.
disposed of within 3 months from today. All right. They have to face so many problems. It's very difficult. Yes. Yeah.
Item 15.
Should we give some more time?
3 months.
He has asked for 3 months, but I don't think they
3 months, we are
can
giving more than 3 months. We are giving him more than what he.
2 months.
Item number 15. Item 15, I do not want to press the IA number 6977 of 2020.
All right.
I do not want to press it.
So, IA number so dismissed as not pressed.
Item 16.
It's again extension.
There should be a findings application for extension of time for compliance of the judgment dated public.
The 2 months you trade for is already over. They trade for 2 months in November.
I am for the workmen responded LOC. Since 2 decades, the workmen are fighting for this relief LOC.
There were multiple casualties and also collectively banker other kinds of implementation. There were some laborers were not supplied with documents, so
That has already been granted to you. Or you have granted to yourself that much of time. Huh? You have got the order modified. Rather, you modified the order of this court. Huh? So why should we not punish you for contempt of court? So we are placing the matter for the next week. Let us know whether you have implemented that or not. Otherwise, we may proceed against you. Will they not implement?
No, they should implement, but since they filed an application,
That is over.
we don't.
That period is over. Why should we grant time? Let's this matter on. Next
3 weeks, 2 weeks. we granted.
3 weeks. 3 weeks. The court may consider initiation of contempt proceeding if in the meanwhile the court's order of which modification is being sought by way of extension of time, comma, is not implemented. So stop.
Item 17. Item 17, my lord, it's a state appeal. There is a delay of 247 days.
No, but we want
Come up with
correction.
correction,
Let's come for correction.
but it's a this. It's not a this, but this was said.
What correction?
The IA number has been typed as 5571 in place of 5671. The order, the IA number has been typed as 5561. Order dated. Order dated 22/9/2023.
IA number 5571 has been typed in place of
5571 in place of 5671.
That is the only thing which is to be done.
Yes, that.
There appears to be manifest typographical error in the order dated. The order
Dated
22/9/2023, wherein IA number 5571 of 2023 has been typed in place of IA number 5671. 5671 in place of IA number 5671 of 2023. First of all, the said order shall be, said order stands modified accordingly. Anything else?
No, in fact, notice had been issued. I don't think any steps have been taken for that. That other notice had
Simple
been issued.
typographical error.
I don't know if
Nothing
they
is-
have not complained.
Earlier, the order was passed.
Yes, on that day, order issue, notice has been issued on the application for coordination of delay. Have you taken notice, Mr. Mishra?
Well, postal requisites has been filed, ma'am.
Okay. Well, as per this, there is nothing that notice has been issued. So that
No, but today,
yes.
Huh? proceed according. Yes.
I don't know, 18. May I please, Your Lordship. There is a delay, my lord, 1 year 17 days. Reason being, originally it was filed with the downloaded copy, thereafter the registry pointed out defects, thereafter I filed the certified copy.
No, but why it has come before us?
Review.
Justice Rathore was a particular.
Seeking review.
Review, now that I find, my lord, review may not be fruitful. So I will withdraw the review, seek extension of the time limit that your lordship had granted at page 34. And to approach the collector within 15 days. If your lordship could restore that 15 days from now. Your lordship may kindly look at page 34. and
You don't want to press this review application.
review. But then unless your lordship condones delay, possibly I cannot make that prayer.
Right?
It is,
You can withdraw the application on that ground alone.
Because-
That it is not by limitation and I don't want to press.
I have got a subsequent prayer, my lord.
That you are saying that prayer you cannot press unless the delay.
Unless your lordship condones the delay. And that is very, ground is bona fide, my lord.
Within 15 days, he would approach the authority. Instead of doing that, he has filed the review. Of course, after the time expired. And the review, why should be granted?
I have filed the downloaded copy, the review.
That has gone.
Then I filed the certified copy. In this and consequences,
You want to press the review, so forget about that.
I seek your lordship indulgence, page 34, your lordship, I can look at. Paragraph 36. Page 34, your lordship. Therefore, either the district magistrate or the commissioner of police, if is so authorized to exercise such power, is the authority which will deal with such dispute. As such, the order dated 7th of 2021, such and such to the writ petition is interfered with and set aside being issued without any jurisdiction. But the opposite party number 2(1), my lord, that is myself, is given liberty to approach the authority, the district magistrate of the district, where the opposite party number 1's land is situated, for removing the transformer which had been installed without her prior permission, and for granting compensation if any. Such petitions shall be filed within a period of 15 days from the date of receiving a copy of this order to the district magistrate if the opposite party number 1 is so inclined. We direct the district magistrate to decide the issue in the dispute if he is approached by the opposite party number 1 and pass a final order within a period of 6 weeks thereafter.
So what do you want?
I want from today, your lordship,
15 days.
15 days,
All right.
and consequently the district collector will be directed accordingly.
Let
No,
counsel for the appellant. Sorry,
Sorry.
petitioner, review petitioner
Review it, sir.
The opposite party.
does not.
I was the opposite partner of 1 there.
The review petitioner does not intend to press this application. Stop. This application is accordingly dismissed as not pressed. Stop. You are senior counsel.
Yes.
You are senior counsel. He has, however, drawn our attention to paragraph 36 of the order dated so and so, urgent, so of which, seeking review of which the present application has been filed. So stop. While petition, while allowing the writ application, the court had granted the petitioner time. Petitioner of that case,
These were the
No.
party one in that case.
Opposite party number one there.
Party number one in that case, in the petition.
Opposite party number one there.
Yes.
Review petitioner or opposite party number one.
The one was permitted to approach the collector for within 15 days.
this review application has been filed by OP,
Yes, everyone.
whereby OP number one was OP number one / the review petitioner was allowed time to file a petition within 15 days from the date of receiving of a copy of the said order to the district magistrate. He submits that the review petitioner bracketed opposite party number one in the petition may be permitted to comply, permitted to act in accordance with the observation made by this court in paragraph 37 of the said order. Said order within 15 days from today. So stop. Considering the facts and circumstances, while dismissing the review application as not pressed, we observe that the review petitioner / opposite party number one in the writ petition shall be at liberty to file, to comply, to proceed, shall be at liberty to file his petition within 15 days from today, as was contemplated in this court's order, dated so and so, iska review hai. As contemplated in paragraph 27 of the order dated so and so.
I have got a further prayer for your consideration. I filed the original certified copy.
Now, this second submission which you are going to make is that after now, my lord should review the order.
You want return of that certified copy?
Certified copy may be returned. Okay.
Right.
Formal, your lordship.
That certified copy of the, why do you want?
You can take
I may
another.
require it there. I may require it there before the collection.
You can get,
You are getting a certified copy these days is also, my lord, is a difficult job.
Sorry?
Getting a certified copy in time of the old matters, it has become difficult, my lord.
let certified.
And substitute by a Xerox copy, my lord, because it requires certificate.
Certified copy of, where is the requirement of finding certified copy? What is the requirement?
Maybe the learned district magistrate.
No, let him take this stand. Let him take this.
Your lordship may pass that order, I will replace
You
it.
can give me a Xerox attested.
No,
copy
let
of
us
the
see
flag.
what happens.
Only the High Court did not accept my downloaded copy, your lordship showed a defect. This original is, this petition was filed.
Collector
with-
and High Court. You
No, I am not
can
saying that, your lordship. Your lordship,
they are party to the present proceeding. This order they may also be having. So let any collector take a plea that because this was merely a certified copy, merely a photocopy of a certified copy, therefore he would not take notice of it. We will see what to do. So let him.
No, I'm not on that, you know. See, I pass that order. I will place it with the ordinary, Xerox copy.
Not required.
Item 19, urgent copy of the lawsuit order.
You will get.
Item 19,
On behalf of Mr. Bahal, kindly next to my lord. On behalf of Mr. Bahal, kindly next to my lord.
Agency. It's been disposed of or very. There's no urgency.
My lord,
I mean, there is no urgency. You filed a review regarding this age limit, right?
yes, my lord. Mr. Bahal is out of session, so naturally kindly taken over next week.
Filed in 2023. Regarding appointment, selection and appointment, fixing the.
Teachers.
No, these are like, what were the posts?
My lord, that is
Police.
not known to me.
Police.
Sub-Inspector of Police.
Sub-Inspector of Police.
So what is the age of the applicant? Petitioner.
Whether extreme is necessary, or we can give a further.
As requested on behalf of the petitioner, list this matter on 4 weeks.
item 20,
Madam, that create 2 weeks time to remove the defects of your.
How much?
State 2 weeks, madam. Since steps for limitation, madam, is a matrimonial proceeding and was disposed of on the compromise between parties, but the compromise could not be worked out. Therefore, for recalling that order, the application is filed.
No, why this matter has been placed before us?
Because madam, his lordship was a
What
party.
is your order? This is CMA-PL. What is this? CM?
This is for recalling of the order.
Recall of the order.
So it was dismissed for non-prosecution.
All right. There is some defects.
In the process, some limitation has to be filed. Stage for limitation has to be filed.
4 weeks time is allowed for the applicant to remove the defects.
item 21,
My please, your lordship, 25 days delay to restoration petition is filed only 25 days delay only, my lord. Because my eyes were, I am conducting were being the conductor were, I was seriously affected in my eyes.
What has happened? Anil?
Then it has been, he's filed a delay condemnation application.
No, earlier for default. Application was dismissed for default.
And I was absent when matter was listed here, my lord.
Yeah.
And I have complied the order 13 March 2023 on 9th August 2023. Para 2, my lord.
Notices. Issue notice. Requisites. Who is the other side?
My lord, government and one the opposite party number 5, private party number 5.
Issue notice. You accept notice on behalf of 1 to 4?
Yes.
Done it. AGA.
Yes.
AGA accept notice on behalf of opposite parties number 1 to 4. First off, the requisites for service of notice upon opposite party number 5 must be filed within
3 days.
3 days. 1 week.
Oh, nice.
item 22,
Yes, may I please, your lordship. Let the Sri Jagannath Temple, Puri, let that is the There is a committee of management with whom the final authority rests. My lords, this writ petition came to be disposed of on 29th of September. And because there was some mismanagement in the Ratna Bhandar and the temple management, etc. There was a demand for this opening of Ratna Bhandar. That's the
Just a minute, your writ petition was disposed of.
yes, by my lord Chief Justice, as is was Justice Talpatra and my lord Justice Ratho. Let your lordship may kindly turn to paras 17 and 16 of the judgment. That this court was pleased to direct the state government to constitute a high power committee as per the recommendation of this Jagannath Temple Committee, headed by either a retired Supreme Court judge or a retired High Court judge for preparation of the inventory of Lord's treasury, that is called Ratna Bhandar. That actually it was initially with Gajapati Puri Raja. The government took it over in 1955 by way of a special enactment. So the Ratna Bhandar is called the treasury of Lord Jagannath, where lots of valuables have been kept, jewelries, diamonds, gold. Everything.
What do you want?
So that was Lord. We want that the committee which was directed to be constituted within 2 months, that has not been constituted by the government so far.
Then file a contempt.
The contempt has already been filed, Milord.
And you
In fact, I'm giving the number, you will see that.
But why do you want to press this? This is
This IA we filed, Milord, because let the direction be given to come forward with a committee, whether they have
I
constituted.
have taken instruction. The direction was that the SJIT, the trust will write to the government and the government will form a committee. My instructions are that the trust has written to the government and 60 days time was given. Within 4 weeks, we will appoint the chairman of the committee. So on that ground, it can be disposed. I record my statement.
With the trust management, it will also look to the paragraph 19 of the judgment. In terms of the judgment, we have already submitted to the government the proposal, and the government is taking action to constitute that committee. And within the time you have granted, that has been done.
So your Lordship may record my statement that within 4 weeks from today,
You could also look to paragraph 19 that is here. Where it judgment, paragraph 19. On the basis of the opinions of the superintending archaeologist as reflected in the said minutes, we cannot infer, contrary to what has been advised by the superintending archaeologist, ASI opinion number 7, by acceding to the prayers made by the petitioner. No malafide has been attributed to the Jagannath Temple's Managing Committee. Even the Appellate Court has observed that the Sri Jagannath Temple Managing Committee has to take steps as it is the sole repository of faith. As no malafide has been attributed in respect of any action of the management, in our considered view, they should be allowed to function in accordance with the resolution. That is important. In accordance with the resolution taken in the meeting held on 4th August 2023. So far as the question of integrity is concerned, we might have taken a view against the petitioner. But the petitioner has raised 2 important issues, that the safety of Ratna Bhandar and transparency in respect of the valuable articles stored in the Ratna Bhandar. Even if we dismiss the application and the question of lotus standard, the court discussion may not refrain the court from delving deeper into the question as Jagannath Temple is the beacon of the ultimate faith of million people. In such circumstances, this is the direction. We direct the state government to constitute a high-level committee if they are approached by the temple management committee for supervising the process of intervention of the valuables, including jewelers, stored in the Ratna Bhandar. Such committee be constituted by the state government within a period of 60 days from the date when the managing committee will approve them.
Mr. Rautra, which paragraph? 19.
Para 19. The page
13 onwards.
page 13 onwards. And the resolution of the meeting of the managing committee dated 4th August 2023, where a decision was taken that the state government will be requested to constitute a committee under the chairmanship of the retired judge of this court or retired judge of the Honorable Supreme Court, and that has been accepted fully. And it has been already, managing committee has already sent the proposal and state government is in the process.
The government is to do. That's the committee. There is no allegation. We are not pursuing any allegation against the committee.
That is
Implemented. The government is to take a final call, and that was directed to be done within 2 months by the Supreme Court.
2 months from the date when the proposal was submitted.
You wrote in August 2019.
That is
7 months.
February, we wrote it on 12th February, because the authority was in the month of July. And we have given a memo also. Copy of the memo, copy of the proposal which was submitted to the government. First we can record it and the rest we can pass. Take a definition.
Since the law and AG is, will not,
Says that committee is to be constituted. Just.
Yeah, page 151. Yes, that is the. Even if it is.
Yes, we have seen the order, but why this IA has been filed, that we are not able to understand.
let the IA usually we file the order is there. I have rightly also filed a contempt petition because
Meaning of IA, I in IA.
interlocutory application, but that is a miscellaneous petition. That earlier it was called miscase. Now they have styled it as interlocutory application. IA.
The final order you want
In
in
our
our.
case, that was interpreters.
Still, in view of the.
We learned since to learn and Beijing will not undertakes that it would be done within 4 weeks. University may record its submission and expose of.
We will not only record his submission, we will post the matter after 4 weeks.
Man, let's simplify. Man.
We will post the matter after.
Yes, yes. In the meantime, let them deeply obliged.
By a decision of this court dated 29/9/2023, rendered in WPC number 20481 of 2023. Direction was issued inter alia to the state government to constitute a high-level committee, if approached by Sri Jagat, what is SJ? Jagannath Temple Management Committee, bracketed SJTMC, for short, bracket close, for supervising the process of inventorization of the valuables, including jewelries stored in the Ratna Bhandar, in the said temple. Full stop. The committee, as per the order, was required to be constituted by the state government within a period of 60 days from the date of the said order dated 29/9/2000. Sorry. From the date when the SJTMC would have approached them.
This happened, my lord, on 12th of February.
That was, they have filed an affidavit. Please. In the affidavit, they have stated, I'm just, please allow me to. So on the affidavit filed by the committee, they have said that we have already forwarded. That is at page 36 of the affidavit. On that basis, it was disposed of. An affidavit was filed by Sri Jagannath committee.
They are on the order.
Yes.
So after the order, whether any request was made or
It
not.
was made on 12th of February 2024.
So that means.
Is there any
That
doubt?
means after 5 months, we submitted it on 12th February 2024.
All right.
We have, I've given a copy of the that later also.
We have been informed by senior counsel representing the SJTMC that a request has been made to the state government for constitution of such committee to letter number 1805 dated 12/2/2024, which 24. A copy of the said letter has been produced before us, which reads as under. ऊपर से लगे नीचे तक. We are quoting.
Quoting that is.
Mr. Learned Advocate General, Mr. Ashok Kumar Parija, Learned Advocate General, representing the state government, has, based on instructions which he has received, informed this court that the committee shall be constituted within a period of 4 weeks from today. Committee shall be constituted by the government within a period of 4 weeks from today.
Lord, I was instructed chairman will be appointed because he will be retired judge of the Supreme Court or High Court. And the committee, the chairman will have a say in the committee. So if you should say, but chairman will be appointed within
Chairman of the committee shall be appointed within 4 weeks from today. So stop. Next. 4 weeks from today. So stop. List this matter again. List this matter on 4 weeks. Usko kaat do. Acha likho. 4 weeks. Acha. Any other thing?
That's all.
Let me go next. I'm happy that the government gets the good signal, and the moment we file the contempt, they come out with the letter addressed to the. We filed the 11th, 12th they wrote, and from September till 12th they were sitting over it. Blast.
Item number 23.
Withdraw. Thank you. Withdraw.
Item 24.
Next.
24, my lord, there is a typo mistake in the, my lord, in the order number 1.
What is typo mistake?
That is in the order number 1, dated 25/8/2023, the nomenclature of the case is.
What is typo mistake? Say typographical. Why? What is the problem? Yes, item
24.
24, yes.
The
Very typographical error.
order number 1, dated 25/8/2023.
Nomenclature of the case. Of WPC, it doesn't type. In fact, the earlier one was also same, but he withdrew that.
All right.
Order 25/8/2023.
There is the case number. While recording the order dated 25/8/2023, the case number has wrongly been mentioned as WPC number 117 of 2023 in place of WPCRL
Yes, ma'am.
117 of 2023. So stop. Party name is correct?
Yes, ma'am.
Sometimes it happens that it generates the
Copy-paste.
party name and uh, no, sometimes it happens that when you enter the wrong number, then party name is accordingly generated. Incorrect party name.
Here you
Here
usually
it
copy
happens.
paste. There's a copy.
No, there it happens that the moment he types the case number,
So the rest
the
of the
party name
Okay.
it is generated automatically.
I think that's
So the body will be here, but everything we know
including advocates and.
everything will change. So the said order dated 25/8/2023 shall be read accordingly and considered to have been passed in WPCRL number 117 of 2020.
Oh, please.
25. My lord, against the order dated 6/2/2013 in OA number 784 of 2011, the state had come up before this honorable court in the writ petition matter. The order of this honorable court, my lord, will find at page 11.
So there is some order under review.
No, that this order we pray for review, ma'am.
You are praying for review,
No,
but you will have to come this side. Come here. You cannot appear for the petitioner from that side.
Still appealing for the state, so that's why state.
No. Yes.
no. So the order against the order dated 6/2/2013 in OA number
6/2/2013.
in OA number 784 of 2011. The state came up to this honorable court in WPC 25574 of 2014, which was.
Where is that order?
My lord, the OA order that is in my lord's record.
No, which.
This writ petition, the order.
You are referring to some order. You are referring to an order.
My lord,
Where is that order?
that order is in my lord's record, the OA record, 6/2/2013.
So you want to-
OA record
That has been scanned.
that has been scanned.
That is there with the writ petition. I'll point out the page. Oh,
Can you find that?
yes. 6/2/2013.
13.
So that is page
Where is that?
22.
Page 22.
Yes. No, but I think this is the wrong day. Because I have. 2257 for. Is it attached with the review? No.
It's not attached to the
Okay,
review.
then please click this.
This one.
Yes. Then click this.
25574.
Yes, that is attached there. Then page 22.
My lord, sir,
Just
Just a minute.
click here also, but then.
Which page?
Next one.
Annexure 1. So you are seeking review of this order.
my lord, we are seeking review of the order of this honorable court on dated 22/3/21, which was passed against, which was adjudicated consequent upon the writ petition of the state against the order of 6/2/13. So may I take my lords to the order dated 6/2/13 first? My lords have it. Now, my lord, may kindly see the page, internal page 7 of that order, 6/2/13, internal page 7,
Yes.
paragraph 12.
Yes.
My lords, may I read?
The learned standing council submits that since the inquiry against the applicant was one under Rule 16 of the OCS CCA rules 1962, furnishing of a copy of the
CCA rules, not OCS.
No, CCS.
Orissa citizens.
OCS, I'm sorry, OCS CCA rules.
Right.
62, furnishing a copy of the inquiry report to the applicant was not mandatory. In this context, the learned counsel for the applicant relies on a full bench decision of the Honorable Appeals Court in the case of Managing Director, ECIL Hyderabad, etc. versus B. Karunakar, etc. reported in AN 94, Supreme Court 1074. My Lord, must keep over kindly. Then paragraph 14, ma'am. The first observation of the Honorable Appeals Court clearly goes against the respondents. Since an inquiry was conducted against the applicant and the impugned order of punishment is passed on the basis of findings of such inquiry, the applicant was entitled to a copy thereof and to challenge the findings recorded therein against him. Since these statutory principles were not observed in the case, in this case, we are of the opinion that the impugned order of the punishment was not passed in accordance with law. It further appears from the judgment passed by the ad hoc additional district judge FTC 2 dated 21/2007 at annexed 12. The respondent number 1 and 3 had filed a money suit bearing no, these are not relevant. Now, my respectful submission to this honorable court will be, my lord, this is what on this ground we have come up in a review. If the honorable court was of the opinion that the tribunal found that the inquiry report should have been furnished, then my humble submission is it should have relegated the disciplinary proceeding to that stage, man, allowing us to supply the inquiry report and to proceed from there. That was the
wrong committed by this court.
My lord, that is, my lord, that is the stand taken.
You could have challenged that. How can you seek review?
That this order we challenged. This order
you challenged and some order was passed,
my lord,
by this court.
And we are seeking review of that.
How can you seek review? On what ground? On what ground you are seeking review?
My lord, in fact, I have not.
Because the order is incorrect. The order may be incorrect.
My lord, in
But
fact,
that cannot be a ground for review. Sorry.
in fact, the entire OA order I have not placed. In fact, the entire OA, that is not the only ground the tribunal dismissed the department proceeding. There was there was statutory infraction. Since the order of the tribunal within that 6 months also we did not.
What are the grounds for review which you have taken in the present proceeding?
Well, this is the only ground that has been taken.
That is not merits.
So he's conceding that there are other grounds also for why the tribunal has passed the order.
I don't know. No, there is no merit.
Go back to
The state of Odisha has referred present application seeking review of an order dated 22/3/2021 passed in WP bracketed C number 25574 of 2014, whereby a writ petition questioning an order passed by the which tribunal? Odisha. By Odisha administrative, whereby an order passed by was affirmed. Passed by Odisha Administrative Tribunal in OA number?
OA number, my lord.
7.
Seven.
Of 2012. 11. Came to be affirmed. Also, next. It transpires that the disciplinary action against OP number?
One.
OP number 1 was interfered with by the tribunal, administrative tribunal, on the ground that a copy of the inquiry report was not made available to him before taking the said action. So stop. Assailing the order of the tribunal, the state of Odisha had preferred the said writ application, which came to be dismissed by an order passed by this court, which is under review. So stop. Next, learned counsel appearing on behalf of the state while pressing the review application has submitted that this court ought to have permitted continuance of the departmental proceeding from the stage of supply of the inquiry report after granting the estate an opportunity to supply a copy of the inquiry report. So stop. Next, we have carefully perused the materials on record and the materials on record, including the order passed by this court under review. So stop. In our opinion, the correctness of the order passed by a coordinate bench of this court cannot be gone into by us while entertaining an application for review. So stop. The learned counsel for the petitioner has not been able to persuade this court that there is any apparent error on the face of report in the order under review requiring this court to exercise such jurisdiction. So stop. There is no other ground available for review of the order. So stop. We do not find any merit in this application, which is accordingly dismissed.
Congratulations.
M26.
Your Lordship, I am appealing for the petitioner. Your Lordship, my learned senior is not available today due to medical emergency. Therefore, this item may kindly be taken up any day next week, Your Lordship.
All right, 4 weeks. What is this about?
Sorry?
What is this about?
This again custody of the child. The relatives, father has taken the child, but they are not being able to meet him.
Yes.
Yes, admission item number 1. Wait, please, my lord. Here, my lord, the petitioner was put into the holiday list and he has suffered a loss of 1 crore. For that reason, my lord, we have filed an application for appointment of arbitrator, my lord.
Where is the arbitration clause?
My lord, at page 122.
Yes.
If any dispute or difference of any kind whatsoever shall arise between the parties in connection with or arising out of this agreement, such dispute or differences shall be resolved through arbitration as per the procedure mentioned herein below. The dispute or differences shall be referred to sole arbitrator. The arbitration shall be through Indian Council of Arbitration. The rules of the above mentioned institutional arbitration forum shall be applicable to arbitration proceeding. The Indian Arbitration Conciliation Act and
Who is
arbitration.
for the other side?
My notice has to go, my lord.
So notice. Requisites 1 week?
My lord.
Requisites?
Yes, ma'am.
1 week?
Yes, ma'am.
Preemptory. Preemptory was also telling which this application shall stand dismissed. All right, without further reference to the bench. Much. Preemptory जब बोलेंगे ना ये लिखो telling which application shall stand dismissed without further reference to the bench. Yes.
Item number 2.
My lord, on behalf of Mr. Umesh Chandra Behra, I pray for an adjournment.
How much?
I pray for an adjournment.
1 week as requested.
Item number 3.
Your Lordship, I am appealing for the petitioner, Your Lordship. Your Lordship, the petitioner has filed the present application under section 11 clause 5 of the Arbitration and Conciliation Act, whereby seeking for a direction for appointment of an arbitrator, Your Lordship.
Where is the arbitration
Your
clause?
Lordship, kindly see annexure 1, page 20, Your Lordship. Clause 17.
Place 20, yes.
Clause 17, Your Lordship. Any controversy or claim arising out of or relating to this agreement or any breach thereof shall at first instance be settled amicably between the parties. In case parties fail to settle the dispute amicably, then the same shall be referred to sole arbitrator appointed by the parties mutually, to which the lesser thereof agrees. The place of arbitration shall be at Bhubaneswar, Odisha.
So was there any attempt to settle the dispute amicably?
Yes, Your Lordship, but the opposite party number 1 has not been paying a single penny nor leaving the premises, Your Lordship.
Was there any attempt made?
Yes, Your Lordship.
Issue notice then.
Yes, Your Lordship.
Issue notice.
Item number 4.
Item number 4, may it please your lordship, and for the petitioner. This is an application for appointment of arbitrator. My lord, the arbitration clause is at page 47, clause 23.
Just a minute, madam.
Yes, ma'am.
Clause
23, page 47 of the brief.
47.
Yes, my lord.
Yes,
May I read it, my lords?
please.
All the claims, disputes, and matters arising out of this order or any way has not been resolved by mutual agreement before the parties shall be settled as per the provisions of Arbitration and Conciliation Act 1996 or any other legislation for the time being in force. The arbitration shall,
Let notice go, madam.
my lords?
Let notice go first.
Yes, my lords. Judgment.
1 week.
Grateful.
Item number 5.
You please, your
Lordship, item number 5, the contract is at
And it starts at page 14. It's for appointment of arbitrator. But this case has a checkered past, Your Lordship. I'll just take Your Lordship's. The Annexure 1 is at page 14, my lord. These are all these insurance contracts, my lord. The arbitration clause is at page 15, clause 7, my lord. Your Lordship has page 15, my lord.
Yes.
My lord, I'll quote, my lord, clause 17. It's at the middle of page 15, my lord. If any differences shall arise as to the quantum to be paid under this policy, liability being otherwise admitted, such difference shall independently of all other questions be referred to the decision of an arbitrator to be appointed in writing by the parties in difference, or if they cannot agree upon a single arbitrator, to the decision of two disinterested persons as arbitrators, of whom one shall be appointed in writing by each of the parties within 2 calendar months, after having been required to do so in writing by the other party in accordance with the provision of the Arbitration Act. And this was the early Arbitration Act, my lord, because, my lord, this, my lord, I should point it to Your Lordship that this particular agreement is dated 1999, my lord, of the year. My lord, that's why I said, my lord, it's a checkered past. I'll just bring it to Your Lordship notice. My lord, this was the arbitration. Now, my lord, what happened is this was an insurance claim. My lord, there was a 1999 super cyclone which hit Orissa right after this. So I raised the claim. They sent the surveyor, there were some questions, there were some factual aspects, my lord. Then an arbitrator was appointed. Arbitrator gave an award. The award was challenged before the, in section 34, my lord. My lord, may kindly have that order. Section 34 order, which starts at, my lord, Annexure 3, page 27.
Yes.
My lord, without doubling elections, I can just take it to Your Lordship the relevant portions at page 40, where the questions was framed by the learned district judge, my lord. At page number 40 of Your Lordship brief, Your Lordship has it, my lord?
Yes.
My lord, the following points are required to be determined for the just decision of the case, and the said points are whether the appointment of the arbitrator by the opposite party claimant is premature. One, when the situation contemplated under arbitration clause 7 of the policy agreement has not arisen by way of fixing of quantum to be paid by the insurance company of the opposite party claimant. Now, there are other issues as well. So, Lordship wants I can do, but the relevant portion is what I'm relying on. Is on the first issue, they came to the finding, my lord, which is as your Lordship's page, my lord. My lord, may kindly have, my lord, page 48.
Yes.
My lord, at the very bottom, 4 lines from the bottom, my lord, has it so from the available materials?
In spite of that, page 47 of
My lord, 48, my lord.
48.
I'm sorry.
So from the available.
Yes, my lord. So from the available materials with the case record, it is held that while the matter was in process for settling the dispute, the OP claimant invoked the clause 7 of the policy agreement prematurely, which was not arising by way of fixation of quantum to be paid by the insurance company to the claimant. Now, my lord, they went to the second portion. Then, my lord, may kindly have the page 50, which is the final para 13. May I quote, my lord, para 13?
Yes.
So far as point number 3 is whether arbitral award dated this passed in arbitration case number this by the sole arbitrator is sustainable under law is concerned, as it is held in the foregoing points, point number 1 and 2, the appointment of arbitrator was premature one and the arbitrator was an associate lawyer of the OP claimant for which the impugned arbitral award is not sustainable under law. So, the award which was passed in my favor was reversed by the learned district judge on the ground. It's my contention, my lord. My respectful submission is primarily on the ground that it is premature. Why, my lord? They said that if you look at clause 7 says that once a quantum is decided.
No, just this was the order passed by the district judge.
Yes, sir.
Then what happened?
Yes, my lord. After that, my lord, I did not challenge this order. My lord, at Annexure 4, I sent them a new notice, my lord, saying that, listen, my previous thing was premature. Now, let me kindly have page 52, which is the new notice.
Well, this was given on 9 January 2023, this order of the learned district judge. Then, my lord, on Annexure 4, page 52, on 23/6/2023, I send them another legal notice. My lord, may kindly see the legal notice. I say that in respect of the aforementioned claim for the work construction, this, my client had earlier given you notice in 2012, thereby invoke clause 7 under the claim. Now, my lord, may kindly see at the bottom, I refer to a Delhi High Court order or judgment, and then I said at page 54, it is therefore in the present facts and circumstances, my client requests your authority to suggest a means for appointment as arbitrator unconnected with United India Insurance Company in a manner directly or indirectly in view of section 12(5). Now, my lord, what do they reply? My lord, the reply is at Annexure 5, page 55, where they say, if I can take a lordship to the final paragraph at page 56. My lord, has it, man?
Yes.
Well,
He has declined.
Well, decline on the ground, they were saying that further the arbitration council does not provide initiation of arbitration proceeding for the second round at the instance of a party who was unsuccessful in the first round. Our point is, we are not unsuccessful, it said that it is premature.
All right. You are issuing notice.
Quickly.
The notice.
And item number 6, 7, 8, and 9 are all similar. They are all different insurance contracts. Same similar facts. Same annexure, same fact.
Going to section 34 and
Yes, sir. Same part.
all right.
Yes. Item number 10. That's item number 10. The agreement begins from page 12. And the arbitration clause is at page 47. Clause 14, dispute settlement.
Page 47.
47. That's my read it, my lords.
Just a minute.
Yes.
Please.
Yes. If over the works any dispute arises between the two parties related to any aspects of this agreement, the parties shall first attempt to settle the dispute through mutual and amicable consultation. In the event of agreement not being reached, the matter will be referred for arbitration by a sole arbitrator not below the level of retired chief engineers / superintendent engineers, not connected in part or wholly this project in service, to be appointed by the first party. First party is the government. The arbitration will be conducted in accordance with the Arbitration Conciliation Act 1996. The decision of the arbitrators shall be final and binding on both the parties. Now, let's at page 223 minutes. 223 minutes, I issue a notice for amicable settlement with 30/10/2022. At page 225, when they don't reply to that, I invoke the arbitration, I will implement the claims. And at page 227, when no reply is sent to the intimation of claims, I invoke the arbitration clause. And as of now, no reply, denying or appointing any arbitrator has been taken, notice as to governments.
Is the notice?
Item 11. 11 is same.
Same.
Item number 12.
May I please, your lordship?
Yes, please.
Your lordship, application under section 11(6) of the Arbitration and Conciliation Act 1986, appointment for independent and impartial arbitrator. There is an arbitration clause between the contract between the parties. As per the clause number 11 and 2, Conciliation and Arbitration Clause, Annexure 2, page number 44, your lordship.
Yes.
As per clause number 44, page number 44, arbitration clause. In the event of any dispute or difference arising under or out of contract, the same shall be referred to sole arbitrator of any persons nominated by the CO cell, Routla, steel plant, Routla, which expression shall mean and include the chief executive of RSP, whatever the name designated. It is further agreed as in terms of the agreement that in the event of appointment of arbitrator to whom the dispute and difference has been originally referred is transferred or become unwilling to, in accordance with this agreement, and such arbitration shall be entitled to proceed with the reference. That means there is an arbitration clause between the parties, and my claim was rejected at the Annexure 6, your lordships. My claim has been.
Let the other side come. Issue notice.
Item 13. That's here, the arbitration clause is at page 24.
Same issue notice.
Issue notice. That's issue notice.
Item 14. May I please, madam? But the arbitration clause is at page 21, madam. Also, can you see? Page 21, clause number 22. 22.5 is the relevant, madam. Any dispute of whatsoever nature as contemplated in clause 22.1.
This is item number 14.
This is 14, madam. Page 21, clause number 22. Also, kindly have a glance. Any dispute of whatsoever nature as contemplated.
Let notice go first.
Madam.
Item 15.
May I please? Item number 15, the petitioner creates for extension time for making the hour, arbitration hour in ICC arbitration case number 2580/STG. But what happened in this case? In the meantime, the arbitration tribunal has reserved the hour for 28/6/2024. So my humble prayer before this honorable court, the date can be extended till 28/6/2024 so that the hour can be completed. Pleadings completed, written note of submissions filed, and it is reserved till 28/6/2024 for hour.
My lord, I am appearing on instruction for the opposite parties. We don't join issues, my lord. We are fine if your lordships can extend it, my lord. It's a fact, my lord. It's already been submitted. The written submission has been filed, my lord, by January. And my lord, your lordship is holding, I think, the letter by the arbitral tribunal requesting for an extension.
Okay. So which jurisdiction I shall be exercising? You want me to extend the date,
My lord.
the mandate
Yes, your lord.
of the arbitrator?
Yes, your lord.
Which provision?
29A, man.
Read that. Please read.
What is that?
Shall I? Yes. My lord, 29A, my lord, it starts time limit for arbitral award. Now, my lord, 29A3 says, the party, your lordship, the parties may by consent extend the period specified in subsection 1 for making award for a further period not exceeding 6 months, which has already happened in this case. Number 4, if the award is not made within the period specified in subsection 1 or the extended period specified under subsection 3, the mandate of the arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified extend the period.
So what is the definition of court?
Madam. I say so. But section 2E, court means in case of an arbitration other than international commercial arbitration, the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the question forming the subject matter of the arbitration, if the same has been the subject matter of a suit, but does not include any civil court of a grade inferior to such principal civil court or any court of small causes.
So whether this court exercising jurisdiction under the Arbitration Act is original court of civil jurisdiction.
Whether
this aspect has been dealt with by any court or not.
With all due humility, this court has in the past has extended.
There is no question of past. The question is whether any this aspect has been dealt with by any court or not. It's a question of jurisdiction. So whether this court can exercise, if the jurisdiction is vested in the original court of civil jurisdiction, then only that court will, or if the expression court is used, then the definition of court as given in the Arbitration Act shall be followed. So this is a question of law which may require final decision.
Well,
Not that simple.
I pray your lordship kindly keep it to the only address so that I'll file some.
Please examine.
Yes, my lord.
Please examine. So, I don't think this matter has not been decided till yet at the level of Supreme Court.
I borrow.
Some high courts might have, and I'll not go by past practice or anything.
Lordship,
Alright.
please, my lord. We'll examine it.
Please examine.
My lord keeps it for next week, my lord. If
As requested on behalf of the
6th of March. 6th of March.
6th of March you want, as jointly requested on behalf of the parties, this matter on 6th of March. It cannot be 6th of March.
That's what I was.
It can be only on 15th of March or
15th of March.
15th of March. In the meanwhile,
I will think.
both of you are required to do a kind of research of the users. All right. There can be one argument that an arbitrator is appointed by High Court, a judge of the High Court, and for extension, the parties will have to go to the civil court.
No, that was one of the arguments which was done. That's why I stopped, my lord, as your lordship said, that your lordship were not going to see the prior practice. One of the arguments raised there was because your lordship had appointed the tribunal.
See, the court exercising this jurisdiction has limited scope of appointment of an arbitrator. This court, if you interpret the definition of the court that way, then it becomes functus officio. Once the arbitrator is appointed, this court does not have any jurisdiction beyond the appointment of arbitrator. All right. The question may arise even for the substitution of arbitrator, this court may have jurisdiction or not. Again, we will have to go by the provisions of the Arbitration Act. Please examine, we will see.
All right, do something. Grateful. Okay. Item 16. Yes. Sorry. My lord, kindly see, my lord, this is a very typical case, my lord. Here, my lord, I was working, here OP number 4 was given that was awarded the tender, my lord. OP number 4 was awarded the tender by MCL for extraction of coal, my lord. Thereafter, transportation and extraction of coal, my lord. Thereafter, my lord, he appointed a subcontractor and they had an agreement, my lord. In that agreement, my lord, all the my lord, we see that agreement for a moment. Page 128. This is between OP number 4 and the petitioner, my lord.
Page 128.
Yes, my lord. The NIT LOA work order will also be collectively referred to as a master contract hereinafter.
We are reading.
My lord, the third paragraph, my lord, whereas NIT LOA and work order will also be collectively referred as a master contract hereinafter. I got it? Or?
It's not that legible. There is no NIT, LOA and work order will also be collectively referred to as master contract.
Yes, sir.
So there is no whereas.
No, sir. Sorry, hereafter. Hereinafter.
Yes.
My lord. So, my lord, after that, the respondent number 4, my lord, wrote a letter.
wrote a letter to himself, my lord, Manali Coldfields, at page 145. What do you want? My lord, I want an appointment of arbitrator. They say that because by reference of under section 7(5) of Arbitration and Conciliation Act, my lord, there is an arbitration clause. That's the reason, my lord, I have come for an appointment of an arbitrator. My lord, may see this letter of Sikol, my lord, has been written to MCL that all terms and conditions of the agreement will be complied by the subcontract MS.
So is he opposing? The other side is opposing?
Yes, my lord. Yes, my lord. They say that first of all, my lord, NCLT has passed the resolution clause plan, approved the resolution plan, where my demand of 6.5 crores was admitted in the NCLT. But subsequently, when my resolution plan was approved, this 6.5 was wiped out because of it was shown zero, my lord. Thereafter, my lord, what has happened? For that reason, my lord, they say that you don't have any claim further, so there cannot be any arbitration. And secondly, arbitration proceeding is not maintainable because SICOL and MCL has an agreement. You don't have an agreement directly with MCL, so there will be no arbitration.
So do you have any? This agreement is between
me and SICOL, where a reference has been made to the arbitration clause of MCL, my lord. My lord, what has happened? I am a subcontractor. I was working under.
There is no question of the agreement is between whom?
First of all, my lord, the agreement is with me.
Who are you?
I am subcontractor, my lord.
What is your name?
My name is Sayom, my lord.
Sayom.
Yes, my lord. He is a petitioner herein.
So agreement is between
Sayom and SICOL.
SICOL.
Yes, my lord. Respondent number 4.
So this agreement is between Sayom and SICOL.
Yes, my lord.
Which you are referring to.
Yes, my lord.
All right.
Thereafter, my lord, in that agreement, the LOA NIT are formed to be a part of a master contract. So when it forms a master contract, that contract is between SICOL and MCL, my lord.
SICOL and MCL.
Yes, my lord. Where there is a
grievance, you have some grievance against MCL.
Because, my lord, MCL has to release that.
Do you have any grievance against MCL?
Yes, my lord.
And
yes.
you want to raise a dispute with the MCL?
Yes, my lord.
Very difficult.
My lord. But because, my lord, what has happened in this case, I know, my lord, I am in a deep water, my lord. What I am submitting is this, my lord. By section 7(5), my lord, when there is a reference of a contract, because arbitration, my lord, so this arbitration clause can be invoked for settlement of dispute, my lord.
Sorry, that arbitration clause cannot be invoked against him.
Because, my lord, because my lord, can we see that data ceremony?
There is no agreement between him and you.
That is one part of it, my lord. Can you see, because they have accepted me as a subcontractor. That is a factor which has to be established.
Maybe you could have entered into.
My lord, can you see?
Mr. Counsel, the question is.
Yes, my lord.
The issue is the question of resolution of a dispute.
My lord.
If the dispute is there between two parties, how that dispute is to be resolved? Maybe through arbitration. It's a process of dispute resolution. No, that arbitration shall only take place if there is an arbitration agreement. There is no arbitration agreement.
That is my reference, my lord.
No. By who is reference?
Because in my agreement, agreement with SICOL, my lord.
SICOL cannot bind him. An agreement between you and him.
My lord, they have kindly see, my lord. Then, my lord, I accept that. My lord, kindly see the letter that has been given by SICOL. My lord, kindly see that letter, my lord.
See, they might have accepted you as subcontractor or whatever.
My lord.
But that on that basis, it cannot be held that there was an arbitration agreement between SICOL and you.
My lord, by reference, my lord. I am saying.
No, but by reference.
That is, my lord, 7(5), my lord. If I read out 7(5).
Yes.
My lord. The reference in your contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such as to make that arbitration clause part of the contract.
So the reference in a contract to a party, read party in place of contract.
My reference in a
reference to read party in place of document.
Yes, my lord. The reference to a contract in a contract to a party containing an arbitration clause.
So you want in place of document to be want me to read party in place of document?
No, my lord. My lord, if I read it another way, the reference in a contract.
This cannot be comprehended even.
No.
This cannot be thought of. The submission which you are advancing cannot be.
My lord, my lord, I'll take one more chance, my lord, if my lord will permit me. If I try to interpret the clause, my lord, for a interpretation. My lord, what I am trying to interpret is this: the reference in a contract. First,
sir, had there been an arbitration clause,
my lord,
to the effect,
my lord,
that you as the subcontractor and SICOL,
my lord,
will be bound by that arbitration agreement.
My lord.
Whether such a condition could have bound them.
No, my lord, what is my submission is this: I have a grievance against SICOL. I have a grievance against SICOL.
You cannot have any grievance against SICOL.
Because my lord, because I have done the.
This application has been filed seeking appointment of an arbitrator under section 11 of the Arbitration and Conciliation Act, 1996. According to the petitioner, the dispute which should be referred for resolution to the arbitrator is between the petitioner and what is that? SICOL?
SICOL is respondent number 4, my lord.
And respondent number 4. And respondent number 4, that is MS SICOL Logistics Limited. So, it is an admitted fact that there is no arbitration agreement between the petitioner and the respondent or opposite party. What do you?
Yes, ma'am. Opposite party.
Opposite party number 4. So stop. The petitioner is, as a matter of fact, a subcontractor of
SICOL now, working and executing the work of MCL, my lord.
That agreement which you are saying was between you and whom?
Because between respondent number 4 and petitioner, my lord. SICOL and me, my lord. Sorry. There, my lord, this clause was there that all the agreement between SICOL and MCL will form a part of this, will be considered as a master contract. That's why, my lord,
the agreement which you are showing was between whom?
Between me and SICOL, my lord. And in that agreement, my lord, there is a clause that that entire agreement between SICOL and MCL will form a master contract.
And they have also written to MCL that whatever payment will be done directly to the account of Simon.
Let me see that agreement again.
Never. That is at page 128, my lord. If I'm
Yes.
here, my lord, there is a reference that NIT LOA in work order will also be collected.
48. Where is the arbitration clause?
Arbitration clause is at, my lord, at page 148, my lord, page 48.
148.
Even 48, my lord, 48.
48.
Yes, ma'am.
That's not in this contract. There is no arbitration clause in this contract. That is, the arbitration clause is in the main, is in the contract between.
Where is that? Just a minute. Where is that?
My lord, page 48. Settlement of dispute. It is incumbent upon the contractor
Yes.
my lord. It is incumbent upon the contractor to avoid litigation, dispute regarding during the course of execution. However, if such dispute take place between the contractor and department, efforts shall be made first to settle the dispute at a company level. The contractor should make request in writing to the engineer in charge for settlement of such
This
dispute.
agreement is between you and him.
This agreement is between SICOL.
So where is the agreement between you and him?
That is my lord, this agreement at page 128, my lord. This is between SICOL and SIOM.
What is that? Where is the arbitration clause there in that?
There is no arbitration clause. My lord, there in that document, in that agreement, there is no arbitration clause. Because, my lord, I was working as a subcontractor of SICOL, so I stepped into as a shoes of SICOL and become the contractor under the MCL. That is my argument, my lord. So, because I step into the shoes of SICOL, so entire work order and LOA, the letter of power becomes a master contract. So, my relationship with MCL becomes a contractual, my lord, where there is an arbitration clause.
Sorry. Dismissed. Dismissed.
Item number 17.
The lordship may kindly see running page 19, my lord.
Yes.
Running page 19, last clause 13, clause 13 is the arbitration clause, my lord. And in case of any dispute, the same shall be resolved by way of Arbitration and Conciliation Act of India, my lord. Thereafter, my lord, by the annexure code, I have demanded for arbitration, my lord. But till that, I have not received any response, my lord.
Issue notice.
God bless you.
Item 18.
May I please, Your Lordship? Your Lordship, the agreement is at page number 9 and the arbitration clause is at page number 12. Clause number 17. May I place it, Your Lordship?
Between you and the other side.
Yes, Your Lordship.
Which clause?
17.
Yes.
Yes, Your Lordship. That in the event of any dispute or difference arising out of this agreement, the same shall be referred to the sole arbitrator that shall be appointed by the landlord or the party of the first part, and the provision or arbitration act shall apply to such arbitration proceedings. The arbitrator so appointed shall have his sittings at Cuttack, and the courts at Cuttack only shall have exclusive jurisdiction over the
Did
issue.
you approach them for appointment of arbitrator?
Yes, Your Lordship, the notice is at page number 28.
All right. Issue notice.
Obliged.
Item 19.
The petitioner filed an application for appointment of arbitrations under section 11 of Arbitration Act. consideration 1950. As per the arbitration clause contained in the agreement dated 12/22/12/2014, Annex 1, page 12.
Where is that?
Para 70. Provide always, and he hereby expressly agreed that.
Which page?
Page 12, Annex 1.
Yes.
Para 17. 17 para. Expressly agreed that if any time there shall be arise any.
All right. This is between you and BSNL.
Hello. Mike.
Issue notice.
Item number 20. Yeah, please, no, sir. There is an application under section 11 for appointment of arbitrator. Now, she can also to come to Annex 2, that is general conditions of contract. Page 78 is the relevant page, bonus. Page 78, clause number 87.
Is 70.
78, 78.
78.
Yes, ma'am. Clause number 87, 87. All dispute. Yes, okay.
So you had apprised them. You.
Yes.
All right. Issue notice.
For orders item 21.
Submitted to withdraw. Withdraw.
Item 22.
Yes.
Item number 22.
Defect. Defective, yeah.
Defect. Hopefully not.
Let the deficit court fee be filed within 4 weeks.
Item 23.
Same order.
Item number 24.
I appear on VC Milan. Item number 24.
Yes, please.
There is an application filed under section 11 of the.
Please remove the defects. Your application is defective.
Beg your pardon.
Your application, it appears, is defective. Defective, huh?
Yes, sir.
Remove the defects first.
Sure, my lord. I will.
2 weeks? 2 weeks?
Yes, my lord. Within 2 weeks, I will report.
Is it defective? Just a minute.
Yes, sir.
Remove the defects. Let the defects as pointed out by the stamp reporter be removed within 2 weeks peremptory.
Item number 25.
Lots item number 27, 26. Same as item number 10.
Please remove the defect.
The defect lots is a non-essential document in the contract which is not visible. It's a diagram. That Millards that may be ignored. That is my prayer. That may be ignored doesn't anyway bear anything on the dispute. That may be ignored and notice may be issued.
What is that? What is not visible?
Page numbers. 2 pages have been pointed out. Page 184.
The defects as pointed out, the defects as pointed out by the stamp reporter shall be considered at the time of admission. Issue notice. All right. Yes.
Much of this.
26.
26 the same. 26.
That is the only defect.
Yes, yes.
Item 27.
Much of less.
Deficit.
Well. Deficit. Oh, please. Item 28. But please, this honorable court.
Remove the defects first.
Well, it's the only defect is service of a copy, but since in the society, the notice anyway has to go in the matter, my lords.
Yes.
Find the arbitration clause at page 15,
What is there?
page 24, my lords.
What is the defect therefore?
Copy not published to
All right. No, issue notice.
Item number 29.
To item 29, I am for the petitioner. The opposite party have to file the counter also. The opposite party have to file counter.
Yes. Who is appearing? Step 4.
Is lost.
There is no representation on behalf of the. Have they entered appearance
Yes, lost. S. Mahapatra and
on behalf of
some
the,
Mangraj.
on behalf of opposite party number 1?
I am.
Who is not appearing? Mr. S. Mahapatra is on whose behalf?
Only sole opposite party.
On behalf of sole opposite party. List this matter on next Friday.
Item number 30.
30, I appeal for the opposite parties.
My lordship, I am appealing for the petitioner. My lordship, we have filed 11-6 application for the appointment to the arbitrator. Where there is a clause in page. In page number, my lordship, in page number 39, there is an arbitration clause. In the event of any dispute in the matter, the same shall be referred to for arbitration to the nominee appointed.
So I am appealing for the opposite party. The entire transaction is in Punjab. The petitioner, my lord, though has a registered office in the state of Orissa. If your lordship would kindly turn to Annexure 1 at page, my lords, 30, the Mohali unit of the petitioner, my lords, who are registered in Punjab, they entered into an agreement with Market Punjab, my lords, for supply of fertilizers. Thereafter, my lords, no cause of action isn't there in Orissa, my lords. Both in my humble submission, my lord, the site and the venue are in Punjab, my lords. Arbitrator, as per this arbitration clause, is already appointed a retired district judge, my lord, and my learned friend is also given that, my lords. They have, he has been appointed. By virtue of an interim order, the arbitration proceeding is pending in Chandigarh, and that is stayed. They approach this court in a Section 9 application. Then the Section 9 application stands dismissed by the commercial court at Bhubaneswar. Then they approach this court in a Section 11 petition, notes. My humble contention, my lord, is both the venue and the site being in Punjab, my lords, if they have a grievance regarding the appointment or for the change of arbitrator, that has to be done in the either in the High Court of Punjab or they have to approach the appointed arbitrator, my lords. So Orissa High Court, my lord, in my humble submission, cannot deal with this Section 11 petition, my lords. And if your lordship would kindly see, the arbitrator has been already appointed at Annexure 10, at page 52. Sri B.C. Gupta has been appointed as the arbitrator, and he is the retired district judge, my lords. And he has given the notices also. And in that notice which my learned friend's client, my lord, has given, the lordship could see page 40 for a moment, my lords. The lordship would kindly turn to page 40, my lords. When I asked them for this arbitration clause, they give me a reply at page 40, Annex of 6. And the profile, my lord, is Advents Group, Paradip Port Trust, within bracket, pockets, so and so, second floor, phase 10, Mohali, so and so, so and so. If your lordship will get it at page 40, my lords. So, my lords, this arbitration.
All right, we will take up next Friday.
Yes, my lordship.
Today's time is over.
Yes, my lordship.
But how do you respond?
Yes, my lordship, can you have a clause for section 11? If both the parties agree to the arbitration,
We have already appointed. My problem is,
they
I'm sorry, excuse me.
have not given us the notice for the arbitrator, for final of the arbitrator. And without notice, the arbitrator itself sending us a notice to appear before him, my lordship. That we have objected.
No, that particular cause,
But that has to be followed by the appointment of the
but that
arbitrator.
doesn't that the state of Odisha and the High Court of
And my
Orissa
lordship,
can
all the transaction has done in state of Odisha, my lordship.
Great.
And section 9,
See later.
pardon my lordship.
It appears to be very contentious matter.
No, if they have a problem with the arbitrator, Punjab is the place, no, not Odisha.
We will see.
Obligation.